Your name? Mr. N. Hope, the learned counsel appearing on behalf of the petitioner, submits that the grievance of the petitioner have already been redressed, and as such, nothing further remains in the instant proceedings. Taking into account the above, the writ petition therefore stands closed, as it had become infructuous. Interim orders, if any, stand vacated.
That's one. I think one of the works have been paper. I have to use that. Final verification needs to be done. And then there is a second sentence version there the department has said the payment has already been made, although they are not giving any confirmation. So what's it like this? See, if the matter can be placed the month of September, and then one of the payments will be made and one
Which are the contempts?
is September 2019 that is being verified.
That contempt is not before me. Oh, this one, 399. নাই দেখোন ইমান এইটো পৰা দিছে দেখোন yes. So as of now, verification is not yet done.
So, this knockout version, the board that we got, budgetary provision is already process verified.
The Mr. Alia, the learned counsel appearing on behalf of the respondent, had placed an instruction dated 16/8/2026 issued by the Director of Health Service to the Additional Chief Medical and Health Officer, bracket FW, Nagaon, whereby it is seen that the wherefrom it is can be discerned that the verification is yet to be completed. The said document is kept on record and marked with the letter X. Taking into account the above, this court fixes the matter on 28th of September 2026 for an update. In the meantime, the respondent shall take all necessary measures so that if the petitioner is found entitled to the amounts, the said be disbursed.
So, matter can be on the same day filed on that day.
Absolutely no. You said the payment has been made, so obviously we'll have it on Wednesday. Produce the document, payment has been made. Don't come up with that, yeah. No, the payment, do you make by cash? Does your department make payment by cash? Then obviously it will be documented. And if you are making a submission that the payment has been made, obviously the document will be there to that effect. So, no, if the payment has been made long time back and you have been provided an instruction, the instruction cannot be only on the basis of a verbal submission, or you have been verbally told out there on the phone out there, look here, the payment has been made. No, it can't be. Well, the petitioner has come out here before this court and said that the payment have not been made. This is a contempt of the year 2019, and 7 years down the line, the matter is still pending. It doesn't look nice. We have it on Wednesday. Mr. A. Solia, the learned counsel, appearing on behalf of the respondent, submits that the payment have already been made as per his instructions. Full stop. He, however, submits that the documentary instructions are not available with him. Considering the above, lists this matter on 21st of August 2026. Full stop. Mr. A. Solia shall produce the documentary evidence which will show that the payment has been made to the petitioner. Absolutely no. You are making the submission. Only question is in 2019 or prior to that, 7 years back, there was an application filed seeking for demarcation. The question why I asked you is, it is not supposed that the demarcation would take 7 long years. So therefore, I asked you as to what happened to that application. The application cannot go to the DLR, obviously. So we asked this particular district commissioner Kachar to be present in the court. This is not how things go. No, you see, is it, do you like, does the department like that the matters to be kept pending for all this while? It is an unnecessary thing. In 2018, he has submitted the application for demarcation. Have you carried out the demarcation? No, that's all. And if you have not, then this court can pass appropriate directions. But the question is that the department, in spite of this, the district commissioner is not providing. You could have very well said that you could not trace out, let him file an application, we'll do it. That you are not saying. You are not making that submission. So therefore, it appears that in spite of this, the steps have not been taken. This is on the last occasion the Chief Secretary have directed the District Commissioner to provide the instruction, and the instructions have not been provided. You do one thing. You file a fresh application for demarcation. And I direct them to complete it within 60 days and ask to file a compliance affidavit before this court. Matter is over. And if the affidavit is not filed, the matter be again placed before me. I think that is the best way how to treat these district commissioners. They are not good for anything. This is the case. The present petition has been filed by the petitioner on account of the inaction on the part of this Deputy Commissioner Kachar Silchar in taking steps for demarcation of the inherited land of the petitioner. It is seen that the demarcation application was filed on 11/6/2018. on account of no steps being taken by the Deputy Commissioner, Kachar, the petitioner had been compelled to approach this court. The records further reveal that notice was issued on 6/3/2019. Till date, there is no instructions which have been placed by the Government Council. In fact, when the matter was listed before this court on 3/8/2026, this court was sought for instructions from the Deputy Commissioner, District Commissioner Kachar Silchar, as to the fate of the applications were submitted by the petitioner on 11/6/2018. A lame excuse has been provided to this court by Mr. J. Hendrick, the learned junior government advocate, to the effect that the records have been sent to the Director of Land Records for digitization. The excuse is apparently lame on account of the fact that for digitization, the application seeking for demarcation could not have been sent. It therefore appears that there is an apparent inaction on the part of the respondent authorities. More particularly, the respondent number 203 in carrying out the demarcation as sought for by the petitioner. Accordingly, this court therefore disposes of the incident with petition with the following observations and directions. The petitioner is granted the liberty to submit an application seeking demarcation of his land within 15 days from today before the District Commissioner Kachar. The District Commissioner Kachar thereupon, upon receipt of the said application, shall direct the respondent number 3, that is the Circle Officer Katigora Kachar, Katigora Revenue Circle Kachar, to carry out the demarcation. Upon carrying out the respondent number 3, upon carrying out the demarcation, shall provide a minutes of the demarcation proceedings to the petitioner. This court further directs that while carrying out the demarcation, the respondent number 3 shall not disturb the possession of any person who is in possession of the land in question. The said exercise be completed within a period of 60 days from the date of submission of the application by the petitioner to the respondent number 2, that is the District Commissioner Kachar. An affidavit of compliance be filed by the District Commissioner Kachar by 7th of December 2026. It is observed and directed that in the circumstance the affidavit of compliance is not filed by the District Commissioner Kachar, the writ petition again be listed before this court by appropriate directions.
Obliged.
Please, Your Lordship.
Yes, what is this?
Lordship, my senior is on legs on court number 1. If Your Lordship may take up the matter after some time.
What is your stand?
I have put the respondent number 3. Release the amount payment only an amount of 10 lakhs is left out.
Where is the direction? What is the contempt? Contempt is what?
What are the page 17, no? Also page
So
7.
you have paid the 3 crores 86 lakhs.
We have paid my lord 4 crores 17 lakhs.
Then what remains?
the 10 lakhs, they have calculated at the interest 4 crore 27 lakhs now. So my stand is that, my lord, whatever the respondent numbers 1 and 2 have released, my lord, I have paid to the petitioner. A small amount has been deducted as TDS, my lord, by the respondent 1 and 2.
Why the interest? Where's the direction for payment of interest? You paid with interest. And they are now disputing the interest.
Lordship, my senior would be,
Who is your senior?
Lordship, Mr. P. Mohondo. He's on legs on court number 1.
Hello. Let him come. We dismiss his petition. We take back the interest from him. You paid 4 crores.
4 crore 70 lakhs, my lord, they have admitted.
My goodness.
Auto, they-
That is too much. Where is it? You have mentioned you have paid 4 crores. Yes. You have not filed affidavit.
Okay, ma'am, because there was a change in the MDs.
Huh?
Post of the managing director, there were some changes, ma'am.
As per number 3, Lordship, there was
Who
some
are you?
changes. I'm 1 and 2, Lordship.
What is that?
The parent department, Lordship, the event.
You have released how much? You have
Lordship,
released
they are to release it, Lordship.
the parent department has paid to them.
Lordship.
How much you have released? Why
Lordship,
haven't you filed the affidavit? This is a 2023 contempt. Why both of you have not filed your affidavit?
Lordship,
Managing director.
Huh?
In the respondent number 5.
Forget about that. You are making a statement.
Lordship, while the matter was pending, Lordship, we had in the meantime paid, Lordship.
Why haven't you file an affidavit in that regard?
Lordship, that can be done because the amount
The
was
done,
paid.
it
Lordship.
done means it is of the year 2023. Does it look nice? That you are not filing an affidavit, file it. We are having it on Friday. This matter, in the meantime, the respondents shall bring on record their affidavit, failing which this court may initiate process for contempt.
Lordship.
Oblige, your Lordship.
What is this? What is the contempt for?
Your Lordship passed an order. What's the discharge?
Oh, that one. One matter should not come. That is Mr. SP Roy's matter. Is that the matter?
Yes, yes.
What has happened?
Why is not here, my lord?
Yes, what is your case, Mr. Goel?
I'm appearing in 6 and 55. Your Lordship.
What is your case?
My case is, my lord. We are, my lord, the sweeper and Mazdoor, my lord, working with GMC, your lordship. Due to fire, my lord, entire house was gutted, my lord. Entire households were, my lord, gutted, your lordship. So, my lord, what,
Oh, you got a stay.
my lord,
Okay, we vacate the stay.
my lord.
Okay, okay.
My lord, the issue is,
No, no,
my
no,
lord,
we vacate
this
the stay.
honorable court.
No, 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 there is already a direction. You had
there
given
is
an
no direction
undertaking.
for vacating, my lord.
Huh?
They have not given me alternative arrangement, your lordship.
No, not necessarily, because your specific stand which was taken. Who are you?
And for respondent 6 to 35.
Okay. Your stand was specific to the affair. At the time when you were given an undertaking that the moment the allotment will be made for others, you will vacate it. Then why can you get this? Where is the GMC?
Undertaking, if your lordship will see impugned order,
No,
page 79, my lord.
No, you gave an undertaking.
I have given undertaking, my lord, to the effect I will vacate. It was on temporary basis. But my lord, unless until they will not provide.
No, you do not have the right on that because there were people whose right were earlier there prior to you. They should have got that year. There was already a
My lord,
direction
my lord,
passed
so-
by me in
so-
another petition.
My lord, that I have annexed, my lord, with my
Where is that?
petition. Page, my lord, 106, my lord.
Hmm.
And moreover, my lord, because of the irregularities, my lord, one inquiry was, my lord,
No,
ordered,
you
my lord.
cannot, order by which the allotment of so and so and the allotment were cancelled as hereby set aside on the ground of violation. It is made clear that setting aside is only to the extent of cancellation of the iman and so and so. However, given it to take against the allotment of iman and by issuing notice to the iman, so and so cannot be made to wait for eternity in the waiting list, taking into account that they have vacated the quarters with the hope that pursuant to the allotment made, they would be allotted fresh flats as per the scheme. So therefore is directed to take appropriate decision. So as regards 2023 month, the said petitioners have a right to be considered for allotment taking into account that they have vacated the earlier quarters. The allotment made subject to the for directed to consider within the limited and make clear that the addition is taken against the petition. But as regards to answer the petition, have been already disposed, the amount and only reason why the possession is on account of pendency of the review which has culminated with the passing of the attack. Petitioners in 3185. Who are the petitioners in 3185?
Karbi Babu, 110, my lord.
Hmm?
110, page 110.
There are two persons.
Sri Narsimha, 2%, my lord. Moreover, my lord, out of 300, may I submit your lordship? Out of 352, my lord, flats, your lordship. So far as we are concerned, my lord, before your lordship, 30 flats they are given to us because of the under, my lord, disaster management committee, your lordship meeting.
Show me how you got it. Show me your undertaking.
My lord, in the impugned order itself, if your lordship.
No. Show me under your allotment.
My lord, there is no letter, my lord, to
But
that.
then you have no reason out there.
In the impugned letter, if your
No,
lordship
you
will
were
see,
not therefore. So
it is
therefore,
79 for a moment.
whereas an order was passed by the so and to the requisition 33 of the steel subquarter duty for temporary accommodation of fire victims under the so in reference to their. Now, whereas now 3 numbers of writ petitions in consideration of the order passed and undertaking given by each of the imam, you are hereby directed concerned to vacate the so. Rightly so.
And my lord, may kindly see page 100.
We do want to, where is the government? With the GMC?
He in court number 4, my lord, he just informed, he texted me. Otherwise,
I'm not going to,
page 119 for a moment. my lord.
no, you have no right. 100 and?
19, 119, 1191.
Yes, what is that?
This is the order, my lord. A committee comprising of the following members is hereby constituted to inquire into the matter of alleged irregularities in the sale and allotment of units flats as mentioned in a letter received from CMO so and so. What has happened, my lord? Some of the flats were allotted to
No,
retired.
you don't have right. You don't have right to question this.
Ah.
Why you are not throwing out? I vacate this in time order, you throw them out. You throw them out and provide an update.
They've been given the undertaking. That when
I
the order
understand.
comes up, they will vacate
You
it.
throw them out, I don't dispose it out. You throw them out. And then this is 33 flats, na?
33.
You throw them out and then we will, the contempt will be complied with.
My lord, only difficulty is, my lord, there is another case, my lord. That is writ petition number 1697 of 25. This has not been listed. There also there is a stay order.
Why didn't you mention about that thing on the last occasion?
I have
You didn't
given the
mention
two
it.
order, two writ petitions.
You mentioned 1695 and 1767.
Yes, sir. One has come up.
Now there are two writ petitions.
There are two writ petitions.
1767 has come and 1697.
Yes, that
95
has not
has
been lost, not been listed. 1695 has not been listed.
It is listed before me.
165. At number 6.
Then you say there.
55,
It is listed. So therefore, we vacate these two interim orders.
yes.
You
In the meantime, we have already taken steps.
Hmm?
Notice has been issued.
You
So
take
that-
the steps. Ask them to vacate. How much time do you require to vacate? You don't have no right to remain there.
If your lordship may take up tomorrow, I will obtain instruction, my lord. As you-
No, today, 2 o'clock. Instruction is only by phone. Isn't it, Mr. Das?
Otherwise, my lord,
Contempt is
for
complete.
my lord, we are, my lord, sweeper, your lordship.
So
Nobody,
what?
my lord, nobody, my lord, house on rent, my lord, to us, my lord. So
So-
far we are concerned, my lord, before fire, my lord, they have given us, my lord, quarters. After fire, they have given temporary basis.
No,
Now-
Mr. Goel, the thing is like this. When you were asked to be there on the basis of an undertaking given that you are going to vacate it, and this was done so only taking into account that the matter was sub judice before this court in those writ petitions. I may very well consider that if, for the purpose of compliance with that judgment, how many flats are required?
33. 33.
33.
And 33 is there.
Have you
and-
considered because there were various directions regarding respondent numbers or petition numbers, so and so. Where is that order by which you have considered the other people?
33 is there.
You see, as regards the writ petitioner in one petition who have already paid, I said they are entitled to. As regards some you had cancelled, which I have revived, giving them that if you want to take an action against them, you can very well take an action but there was a failure of natural justice. As regards the others, they have been already allotted, but I have asked you to consider. So now, where is your consideration?
33 will be considered. 2 will have to be straight away given. 2.
2 has to be given.
That 33 all are given. They are occupying it because of fire. With an undertaking, the moment this order comes up, they have to vacate it. But in the meantime, this petition has come.
No, no,
Lordship vacates it, will start the operation again, my lord, because the already notice had been served. They will have to vacate it, and all the 33 persons, they will get it.
My lord, may I submit, my lord? As regard, all right, my lord, they may vacate us, my lord. But so far as, my lord, petitioners before your lordship in earlier, my lord, it was found, my lord, that husband and wife were allotted 2 quarters. My lord, retired person were given 2 quarter, your lordship. And the person who died, who has also been given quarter.
You are nobody to say. You got there because at that point of time, on account of some fire, these people were nowhere to remain, so they were temporarily you were given with a clear undertaking that look here, whenever the writ petitions get disposed of, you may have to vacate. And you have now, the writ petitions have been disposed of. So therefore you are to vacate. And those orders are not put to challenge. So therefore, you are to go to that. You have no right out there to remain. We need to vacate it.
My lord.
Well, 15 days?
Tomorrow, my lord, kindly take up tomorrow, my lord, at 10:30, my lord.
No, 10:30 at 2 o'clock.
Mm.
List this matters tomorrow at 2 o'clock for final disposal. Tomorrow. 2 o'clock. I'm not extending the interim order.
Fine.
If you want to throw them out, throw them in the evening.
7 and 8.
Me, please, my lords. The matter pertains to land acquisition, my lords. This matter, what falls for my lords' consideration is whether, my lords, once the land has been acquired, can the quantum of land be reassessed and altered, my lords? Now, what had happened, my lords, the petitioner is the absolute owner of 3 katha 10 lechas of land, my lords. And due to the construction of the NH 37, 11 lechas of land was acquired, my lords. Now, initially, my lords, for the 11 lechas, the compensation for the land and compensation for the boundary wall was also paid, my lords. Now, thereafter, when the earthwork started taking shape, my lords, the petitioner realized that 11 lechas would also encompass her dwelling house, my lords. She made representations, my lords. Pursuant to the representations, a joint survey was conducted, my lords. Now, while conducting the survey, the circle officer gave a finding that no 11 lechas of land is not required. We only need 7 lechas of land. And if 7 lechas of land is acquired, then the dwelling house is not acquired. So there is no compensation for the dwelling house. Now, representations were made thereafter on the ground that once you have assessed and you have taken 3G notification has been issued, the land would vest on the government, 11 lechas. And now it is immaterial whether you want it or you don't want it. The stand taken in the affidavit is that we are not even utilizing that remaining portion, my lord. But that is immaterial, my lord, because that has already been acquired. Now, that was the issue, my lord. Now, during the course of the case, my lord,
Interim order?
there's an interim order not to demolish the dwelling house, but there is a contempt application also, my lords. They demolish my boundary, the gate, and other, my lords.
Understood, but
Yeah.
why there is a once, on one hand, you are saying that
Yes.
that part of it has been acquired.
Yes, yes.
Go both ways.
No, no.
Because if you here say that, look here, the land has already been acquired under treaty. So therefore, I don't have a right. This is one part of your submission.
Right, right.
Then how can there be an interim order passed in respect to that portion if it falls under 11 lectures?
Yes.
There cannot be an interim
Yes,
order.
yes. But they have disputed, my lords. They are saying that we're not acquiring 11
It's a
lechas.
different thing.
Yes.
But once a 3D notification has come, once a 3D notification has come, the land vests under 3D2.
Right.
There's no quarrel with that
Right,
proposal.
right, right.
So therefore, if they say that we want, they have to issue another notification, thereby saying that this particular notification in respect to this is being taken away. Have you done that?
My lord,
In fact, there's an order by my lord.
Mr. K. Gogoi in contempt, my lord, he has received the instruction because contempt has been filed regarding my lord
Contempt will
demolition.
drop it immediately. Don't worry with the
Then my,
contempt.
then my lord,
I'm on the
my-
question of
my-
have you issued the 3D2 any notification, thereby 3D2 was
In fact, my lord,
insofar as the petitioner has been revoked.
my lord, may kindly peruse my lord's order, my lords, 17/12/24.
Para 3, my lord, it says.
Now, as regards 7 lectures, 11 lectures, you have already paid the compensation.
Yes, my
As per 5, to the tune of around 5 lakhs.
yes.
We've already paid. Now, some official of yours say that we don't require 11 lectures, we require 7 lectures. For that, you need to have a 3D, by which you have to modify the earlier 3D, which you have not done. So as of now, you have acquired 11 lectures, you have paid him.
We have paid 11 lessons for 11.
No quarrel with that. Now the petitioner says that the land, the house was not taken.
Yes, my lord,
Listen, Mr. Das, you are not understanding. I have, means it's a simple case which is made unnecessarily complicated. The petitioner says that I have not been paid the compensation for the dwelling house. So what is the recourse to the petitioner? He has to go under 3G5 before the arbitrator. Why is the court entertaining this dispute? As of now, the land has been acquired. And if in the later point you say that 3D, you issue another notification of 3D, thereby saying that this part we are relieving it to him, or giving up or amending that 3D, then he will be further entitled to the compensation for breaking whatever may be.
Yes, yes.
It's a thing which is thought of, which may happen, may not happen. We are not in the realm of to do it. As of now, you say that the 11 letters, now see, the petitioner is still in possession of 4 letters.
4 letters. My affidavit also says.
Well, is in possession. Take over the possession of 4 letters and go ahead. And if the petitioner is aggrieved, the petitioner will file an application under 3C5. Matter over.
Yes, sir.
My lords,
Nothing remains, Mr.
Yes,
Damohanta.
yes,
This is not
just
the
one-
court where you are to do all
just
these
one,
things.
one submission, my lord.
No.
We initially approached this honorable court because they tried to reassess and alter the 3G, my lords. Now, they said, my lords, in the order, we have challenged one of the orders where they now say that they don't require the 11 letters.
No. Whether they require 11 letters or not, that is their lookout. I'm not on that. But by dint of the notification under 3D2, the land in respect of 11 letters now vests
That's-
upon the
yes,
central
exactly,
government.
That's my exact
So
point.
therefore, if a part of the house goes and that house is not being brought within the term of the compensation, you are to move before the arbitrator. This is not the forum
I
where
could
you
have-
are going to do it.
Exactly, I have understood, my lord. I could have only moved before the arbitrator, provided they withdraw that letter, my lord. which
No,
says
no,
we
not
justify the 7
necessary.
letters.
No, and I make it very clear.
Yes, yes.
Once a 3D notification has been issued,
Uh,
the land vests
Yes, yes,
of 11 letters.
yes. It's my,
Now, if you have not been able to take possession, take over the possession as per law. You go ahead. If he has any quorum, he will go and ask for that, what you call the compensation. If it's inadequate compensation, he will go before the arbitrator. Matter over.
now, my lord, if I may only point out, my lord, the judgments of this honorable court and the Supreme Court, which says, my lord, in acquisition matters, after the land vests with the government, it cannot be altered or reassessed, my lord. There's a judgment of this honorable court and the Supreme Court also, my lord. Similar circumstances and same acquisition, my lord. What was done, my lord? There were complaints made, some other matter, my lord. Complaints made with regard to the quantum of compensation. And thereafter, my lord, the compensation was reassessed by the CALA, my lord, the land acquisition officer, my lord. So the petitioners approached the High Court and there's a judgment by Honorable Justice Surana, which says the National Highway Act does not vest any power for reassessment of the 3G, my lord, once it has been issued. So that may kindly be observed, my lord. And there's a Supreme Court judgment also. In fact, a number of judgments, my lord.
No, you
Even
have
if it is
already
not
taken
utilized.
5 crores.
My lord.
5 lakhs you have already taken for the 11 letters.
11 letters. 11.
You have already taken.
yes.
So therefore, the
Now, I had
question
seen
of
the
you,
instruction, it says to recover the money, my lord. I just saw the instruction.
the instructions may give whatever may be. That is not the question. I'm not concerned with that. But you have received
Yes,
5.5
I
lakhs.
pleaded case, my lord.
They say that they have to, if it is for 7 letters, it comes to some 3.5 lakhs, half lakhs. They say. They say that the amount needs to be returned, then we can go for 3D. These are things which are not there. If you want to go for 3D, a fresh one you have to issue, that you can. Now you see, as per the Land Acquisition Act 1894, there was no provision by which you can return it back.
Exactly. Section 16.
Huh?
Section 16, it says only when possession is taken, land would vest, but NH Highway possession is not sine qua non, my lords, for vesting of the land, my lords. The earlier act.
No,
yes.
you see, there is no provision earlier, as per the Land Acquisition Act, never said that you are going to return it.
Right.
The land always remains there.
Yes.
So therefore you cannot. But in terms of the Right to Rehabilitation Act, you can. You can very well return the land. That provision is there, right to. Now the National Highways Act is not there. Doesn't say anything. It says only vesting by way of a notification. Now, the moment there is a power to notify under section 21 of the General Clauses Act, there is also a power to modify. That's your lookout. I'm not on that. Why should I give advice
Observe
to
that,
all
my
these
lord. The
things?
judgment, I'm just producing it.
No. All these other judgments you will go. Where?
Guwahati High Court.
No. You won't go to the- You show me a Supreme Court judgment wherein it says that national highway cannot modify.
Yes. Not national highway, it is with regard to the earlier act, like my lord said, the 1886.
Obviously, that I know. 1894, there is no power there. It is categorically mentioned. Do you remember at one point of time, there was this land acquisition, huge problem out there where Tata Nano was supposed to come to West Bengal, Singur. There was that problem, whereby the land was already acquired. And after acquisition of all this land, they cannot be returned back because the Land Acquisition Act does not provide it. On the other hand, the act was very clear, you could not. Therefore, now in 2013 Act, there's a specific provision you can return it. And if you don't use it for 5 years, it is an automatic return given back. That I'm not concerned. Why should I go into that? It's a simple matter. Here you have assessed 3D has not been modified. Whether 3D is permissible to be modified or not, that is a lookout where Mr. Mohanto may challenge at a later point of time. If Mr. Mohanto is aggrieved by the amount of compensation here, and now if the land is there, take over.
Just one observation kindly, my lord. They say it on affidavit, my lord, and even the documents appended to the writ petition would show. They are saying that if 7 lectures are acquired, the boundary is still the boundary gate and the veranda. And they say if 11 is acquired, only then the dwelling house would come into the picture, my lord. Lordship, kindly, that would help me before the arbitrator.
That's an affidavit, no? It's on affidavit.
It's on affidavit.
Lordship, kindly observe that.
Why should I? The affidavit is already there. It's a proof.
The 7 acres which have been acquired, they fall under the government land.
That is
Government land, where the gate and the boundary wall is constructed.
Lordship may read the affidavit. What is the submitting? My lord? Lordship may read the affidavit.
Mr. Counsel, why should I go in whether it is government land or not? See the simple case of the petitioner, although it may try to be made complicated. His case is that look here, my land in a notification on the 3D, my land of 11 lectures have been sold. Against that, a compensation package has been made under 3G1. And therefore, my land, I have been paid an amount of some 5.5 lakhs. Now, when I find out that while calculating the 11, while making that compensation package, they have not included the dwelling house. When they raise the issue before the Kala or whoever it is, the Kala says that we don't need the dwelling house and therefore we want to reduce the amount to 7.
Exactly, my lord.
This is his case. He says that once a 3D notification, the land vests upon the state. And under such circumstances, you cannot revert back, isn't it? So therefore, if that 3D notification, whether you can or not, it is a looker. You have not as of now come up with a 3D. But what the fact remains that with a 3D notification being done, in respect to the land where it is mentioned, the land vests upon the state. And then in the 3D notification, you have mentioned the name of the petitioner for that land. So if you have done so, whether he is entitled to 1 lakh or 10 lakhs or 15 lakhs, it is you have already assessed. If the petitioner is aggrieved with the quantum of compensation, let the petitioner approach 3G, 5.
Submission made by my friend is against his own affidavit. my
No
lord.
more. Remaining is for the division bench to consider.
Clear, pleasure.
Heard Mr. P. Mohanto, the learned counsel, appearing on behalf of the petitioner in the writ petition as well as also in the contempt application. Ms. Yudas, the learned additional senior government advocate, appears on behalf of the competent authority of land acquisition. Okay, none appears for the color. None appears on behalf of competent authority for land acquisition. You are appearing for whom?
For item 8, my lord, 567, not in the contempt, but for the in the writ petition, my lord.
And she appears in the
Contempt, my lord.
contempt, okay. So and so appears on behalf of the competent authority of land acquisition. And Mr. So and so appears on behalf of NHIDC. Miss Yuda, the learned counsel, appears on behalf of the contemners in contempt in the contempt proceedings. The brief facts of the present case. The brief facts in the writ petition of the petitioner in the writ petition is that the petitioner is the owner of a plot of land at measuring 3 kata 10 lectures covered by PP number 384, covered by DAG number 1121, included in PP number 384, situated at village Kotual under Mora Bazar, Moza of Amguri Circle, Revenue Circle. Where's your 3D notification? Where's the 3D
There's a
notification?
3G, my lord. What had happened during the course of the hearing, my lords, the state had submitted that inadvertently 3D was never published.
Then there's no vesting.
No, this 3G is there, my lord. Lordship must take that affidavit.
No,
what
no,
I said.
forget about 3G. 3G cannot come unless there is a 3D.
My lord, Lordship may peruse my lord's order. My lord.
No, no, no,
passed an
no.
order.
My question is not there. 3D has not happened.
Plus 17, 12, 24.
Now, my
lord has-
question is whether there is a 3D notification or not.
My lord may kindly peruse my lord's order, my lord, 2012, 24.
I'm not on that. I'm asking whether there is a 3D notification or not. So if there is no 3D notification, there is no acquisition. And if there is no acquisition, therefore it is a case of they taking over his land without due process. Matter ends there.
Well, can it be taken up on Friday? I'll get the
Why?
instruction, man. Friday or Wednesday, my lord.
Why? Why Friday, Wednesday? Where's the 3D? Because there is an order passed by me on a particular date.
2012, 24.
Tomorrow, my lord.
It is the prime facie opinion of this court without a notification, the land does not vest in the central government. You thus, the learned additional senior government submits that a competent authority along with the heirs shall take due steps. It is further observed that without a notification under 3D of the heir, the possession cannot be taken over by the remand, and as such, the respondent authorities are directed not to disturb the petitioner till a notification under 3D has been issued. You have not issued 3D. You appeared in this matter. Then, on account of the change of the councils of the government, no proper instructions have been placed before this court as to whether a 3D notification has been issued. Thereby, under 3D notification under the National Highways Act 1956 have been issued. It is relevant to take note of that this court, almost more than 18 months back, by an order dated 2012-2024, inquired with the learned counsel appearing on learned additional senior government advocate Ms. Yudas as regards the 3D notification. But till date, nothing has been placed before this court. A final opportunity is granted to the respondents. To read petition to produce the 3D notification whereby the land of the petitioner is notified in the said notification, failing which this court shall proceed to dispose of the writ petition on the basis that the said actions on the part of the respondents is without jurisdiction. The said actions on the part of the respondents to take over the land of the petitioner is without jurisdiction and an infraction to the rights of the petitioner under Article 300A of the Constitution. List the matter on Friday.
My lord, but my instruction, my lord, in the paragraph 3, the language says, my lord, can I read for a moment?
3D notification is not issued by Kala. The 3D notification is issued by the central government. Where is the central government notification? It has to be gazetted. It is not by way of a hand or a paper notification or just a piece of paper which you give it to anybody.
I'm not into that, my lord.
Where is the 3D notification? Do you have a 3D notification or not? If you don't have, come up clean.
Friday, my
Contempt. Now contempt, we take it up.
Yes.
Ask that particular person to be present. Why did you violate in spite of the order passed by this court?
My lord, it has not been violated, my lord.
No,
Because
there is an
no,
order passed by
the
this court.
instruction-
Yes.
My lord, direction was not to
To ensure that till next day there shall be no damages to the dwelling house of the
Yes.
petitioner standing on the plot of land.
Now they have admitted to the contempt. I'll very briefly submit, my lord. Their contention is we did not do anything with the dwelling house, but we broke the gate. We demolished the veranda, the angan of the house.
No.
Now there are judgments which says, my lord, dwelling house does not mean only the house, my lord. It
No,
means
no.
everything. I'll place that judgment, my lord.
My lord, Baron.
They have admitted it.
No, first of all, you don't have a 3D notification. Why without a 3D notification you break somebody's house?
No, my lord.
I've given
house is not
pictures.
Broken, my lord. Lord,
JCB.
It is a serious infraction. Who has done this?
photograph, my lord.
No, I think we hear these persons. Let these persons
No
come.
demolition, my lord, in his dwelling house.
No,
with
dwelling house,
veranda, my lord.
forget about that. You don't have a 3D notification. Without a 3D notification, how on earth have you taken any action out there? Even broken a slight footpath also. Forget about that. You could not have.
No, my lord.
So
we have
these
not
are the
done.
persons who were responsible. The chairman of the National Highways Act. Why you make the National Highway Authority chairman?
That may be, my lord.
We strike out his name. Then
The name
we
is
make the general manager,
C. ALI,
the
circle
deputy
officer.
commissioner,
My-
these persons responsible.
No, dwelling house, my lord, we haven't touched.
By Friday, put the wall and gates properly.
Wall, my lord, this is my lord.
No, put the gate,
Bamboo,
put
my
the gate and wall properly by Friday. We'll have it on Friday and give photographs that the wall and rear has been done properly. Else pay compensation to whatever loss you have happened to the petitioner.
my lord.
No, I'm not on that.
Oh, gate and my lord, this is the photographs, my lord.
No, these
And
are
we
the
have to
photographs
touch the
also.
veranda, my lord.
These are the photographs also which are there. Which photographs are there?
They have admitted, my lord. They have, what does dwelling house
What are
mean,
these?
my lord?
No, forget about that.
Broken veranda. my
Now,
lord.
why
So
have you
this,
entered
my lord,
into
we
his
have to-
place? Why have you entered without a 3D notification? Without the land vesting, isn't it the case by which you have taken the law in your own hands? Is this the manner in which the government function is performed?
3D regarding.
Without a 3D notification, how can you even touch somebody's house? Tomorrow, would you like your house to be broken up and then they will say, okay, someday we will issue the 3D notification? No. Then, if you don't say that, yeah, it also impacts the petitioner's rights.
Yes, my lord, but interim order we have not violated. That is.
You have violated and you, in the meantime, you make
my-
good. Make good this thing by Friday. No, you are not. You are appearing for somebody. Oh, yes, tell me.
Yeah. We have filed our affidavit, Your Lordship.
3D?
3G we have.
3D.
Lordship may find my.
I'm asking you whether there is a 3D notification.
for that I have to take instruction. Your Lordship.
Take for the 2 years for you to obtain that instructions.
Lordship, the portion which have been demolished, that fallen in the government land, Your Lordship.
I'm not concerned to that
For
effect.
that, we have paid the compensation, Your Lordship. Your Lordship may find my affidavit, Your Lordship.
Well, his submission is self-contradictory. He's saying it's government land and for that we have paid compensation. If it is government land, why will he pay compensation, my lords? First, he should
For-
read his brief,
no,
my
no,
lords.
not for the land. It's for the Girard, for gate and the boundary wall, Your Lordship.
Now, there was a,
Show me,
I have,
show me your 3G which shows,
Lordship.
where?
My affidavit, Your Lordship, 36, please.
In the repetition.
In the contempt.
Where?
In the contempt, Your Lordship. Yes. Serial number 9, page 36, Your Lordship. Serial number 9, government, tag number government, pata number government, type of land government. Lordship has seen. May I read the relevant para, Your Lordship? Lordship order was, may I read the order, Your Lordship?
What is this annexure A to your writ petition?
it is the 3G notification showing the amount of lands.
There cannot be a there is never a 3G notification.
Page 18, my lord. Land valuation is given, my lords.
How much?
5,59,680. Starting, my lord.
Please,
Srimati Deepa Gogoi, husband so-and-so. The 6th or 7th column, my lords. 5,59,680.
date, subsequently in the contempt case, Your Lordship, we have filed our affidavit, whereby we saw that the portion of land, that means where the gate is standing and the boundary wall is standing, that fall under the government land, Your Lordship. And that amount is 4,78,908.
Why have you paid 5,76,000?
My lords,
Five.
once my learned friend completes, my lord, lordship may kindly produce the affidavit filed in the writ petition by NHI DCL, my lords. They're trying to mislead this court, my lords.
May I read the
All of a
relevant
sudden,
para, Your
in the
Lordship?
contempt application, they file an affidavit stating which is contrary to their stand taken in the writ petition, my lords.
Lordship, may peruse para 9 of my affidavit.
Only come to para 8 of your affidavit filed in.
Exactly, my lords. I was referring to that, my lords.
In contempt case, Your Lordship?
Whatever they want to
Oh, in
submit,
the
they would
writ
submit,
petition.
my lords. All of a sudden, government land.
Lordship,
In the affidavit filed in the writ petition,
read it.
paragraph 8.
Only 14 feet land acquired from the land of the. In fact,
4 lines from the bottom. Para 8.
Para 8, Your Lordship.
Prior proposal 11 lectures
11.
was acquired and accordingly compensation had already been paid as per 3G notification paid to 11 lectures of land though actually 7 letters have been acquired. What is this statement then?
Last
is
line
it?
also, my lord, would produce. They
Who is-
admitted.
Who is this person?
It is also mentioned that there are trees, culvert, iron gate. Now totally a contrast stand, my lords, in the contempt, my lords, that the iron gate falls in a government land.
You cannot come up with.
In the contempt petition, your lordship,
No, contempt cannot be different. What you have done.
in lordship, may lordship may kindly peruse the order of the honorable court, where lordship has specifically directed the respondent authority are not to ensure that till the next date listing, there are no damage caused to the dwelling house of the petitioner standing in the plot of land covered by Dag number so and 384 and 1000. Lordship, we have not touched this.
Did you demarcate that land where you have done does not fall within dark number 384?
Subsequently,
Before
lordship,
breaking
we have,
it?
jointly
Did you
raised-
demarcate it? Yes, madam, did you demarcate it? You are appearing for some of the contemners. Did you demarcate it? You have not done it. You have taken a plea that, look here, the court have only said dwelling house, so we have broke the gates.
My lord, there are, my lord, instructions more than that also.
No, those instructions would not help you. My question is, I'm not on those instructions.
But
This is
the
a matter
matter-
going on for the last 2 years,
My
3
lord,
years.
Sorry.
Cannot go like this.
Yes, my lord, whether 3D has been.
First of all, 3D notification is not there. How can you enter into somebody's house or land?
My lord.
Both the departments should get ready and make the things good for him.
My-
The particular wall. Wall is been broken.
Iron gate, wall, everything, my lord.
My lord,
So in the meantime, make the assessment and provide the assessment, what is the loss caused
my lord,
and how much each of you will pay.
my lord,
All of you.
my
The
lord.
contemners had to pay to make good,
Fix tomorrow, your lordship, I will-
not tomorrow, Friday.
Friday, they said, at that time. not the
Friday, get the details as to how much is the loss occasion to the petitioner, and then I will pass the directing these officials to make the payment. Then the petitioner will make it from answer, not to disturb. You cannot take like this.
My lord, my lord, my lord.
List this contempt application on Friday along with WPC number so and so. Pusto. The contemners herein. Pusto. At the outset, this court finds it relevant to take note of that the petitioner have unnecessarily dragged the respondent number 1 in the instant contempt proceedings. 1 and 2 in the instant contempt proceedings. And accordingly, the names of the respondent number 1 and 2 are stricken off. Insofar as the respondent numbers, and accordingly, the respondent numbers 3 to 7 are rearranged as respondent numbers 1 to 5. Counsel appearing on behalf of the petitioner shall file a fresh memo of parties before the registry of this court by tomorrow, and the registry on the basis thereof make necessary corrections in the cause title. This court also observes the respondent number 1 to 5 shall provide an estimate before this court as to the loss which had occasioned on account of breaking of the walls as well as the gate of the petitioner by the respondent authorities, by the said respondents on the next date. Friday is the matter. Friday.
Deeply obliged. my lord.
Okay.
Lordship, as per your Lordship order, assessment has been done, Lordship, and this is the report, Lordship.
The return
Lordship, no,
No, my lord.
On
On
12th
12th of
August,
August, my lord.
directed to take steps with the district to demarcate the 14 bighas of and further see to it the possession thereupon is handed over to the petitioner.
yes, Lordship, demarcation has already been done, Lordship.
Handover.
No, my lord, it is
Handover
not-
has not been yet been over, but it will be done within a short span of time, Lordship.
Mr. R.M. Das, the learned counsel appearing on behalf of the respondent number one, na? Respondent number one
One way.
submits that demarcation of the 14 bighas of land has already been carried out and the handover of the said land to the petitioners would be carried out in a few days' time. Full stop. And the handing over of the possession would be done within a few days' time. List this matter again on 28th of August 2026 for an update. In the meantime, the respondent number one, along with the other respondents, shall take due steps for handing over the possession of the land demarcated to the petitioners. Yes, what is this?
They filed an array for including the present incumbents.
Want to make whom? 4 and 5?
For in paper.
Opposite party 4 and 5.
But
Icon allow 4 and 5. So issue notice making it returnable on 28th of September. Eto main khonot hobo, huh? You file your memo of parties within 2 days. I disposed. Mr. Dotto, where is he? 11 is our sir. Yes, what is the instruction? Who appears?
Well, for the DC Borpeta, I have a information that already the proposal has been submitted to the Panchayat and Rural Development Department. So PNRD department has to disburse the amount.
Mr. PNRD, what has happened?
Sir, my lord, we have received the vouchers from the district, my lord. Now, why this letter, my lord, we have requested because finance departments, my lord, as per our last query, they have required one, my lord, certificate, my lord. So we have requested the district commissioner to issue that certificate so that we can send the proposal to the finance department, my lord.
So what do you want? It's a very
Yes.
complicated type of letter written by you.
My lord, only we want to meet the requirement of the finance department query, my lord. Only thing is, my lord,
Finance department say, department is requested to furnish views of the judicial department. That is one.
that is, yes.
Copy of the verified bills, public vouchers, and a certificate on duly audited bills. Now, what do you
That
want?
certificate, madam. Only that certificate.
Only the certificate from the
District Commission.
district court.
Yes.
So this communication has been issued on 7/8 to you, Mr. Nath. Communication has been issued on 7/8 to you.
One.
So therefore, you have to provide the certificate.
Certificate can delay হয়েছে।
Okay.
Well.
In pursuance to the order passed by this court on 22/6/2026, Mr. Ina, the learned counsel who represents the deputy commissioner, the district commission, deputy commissioner Borpeta, had submitted that the proposals have already been sent to the commissionerate of PNRD. Mr. S. Dr. the learned standing counsel of the
PNRD department.
PNRD have placed before this court a communication dated 7/8/2026 asking the district commissioner Borpeta to provide a certificate on the duly audited bills. The said communication is kept on record and marked with the letter X. Full stop. The learned Mr. S. Dr. submits that on submission of the certificate on duly audited bills by the District Commissioner Borpeta, further course of action can be taken before the Finance Department for the financial sanction.
Right.
Mr. Dinad, who appears on behalf of the District Commissioner, submits that the needful would be done. Taking into account the above, list this matter on 23rd of September 2026 for an update.
Right.
Present incumbent, this is the earlier the deputy commissioner who is a party, he is no longer there.
Not necessary. They have
I love it.
This I have for my lord striking with the name of the respondent number 11 to my lord 42. There is the private parties.
What do you want?
My lord, for striking out the name of the respondent from 11 to 42.
11 to
42. My lord, these are private respondents, my lord, and there is a disputes.
11 to 42. This is an application filed by the petitioner. Petitioner
Yes, my lord, petition.
for striking out the names of the respondent numbers 11 to 42 in the accompanying petition. Taking into account that the petitioner is the dominus litis, this court allows the instant application, thereby striking out the names of the respondent numbers 11 to 42 of the accompanying petition at the risk of the petitioner. The counsel appearing on behalf of the petitioner shall file a fresh memo of parties before the registry of this court within 3 days, and the registry thereupon shall make necessary changes in the
Well.
post title. I extend this post.
Deep.
Lordship, item number 2, Lordship. Here, Lordship, I just verified with the officers. I informed my learned friend also. Lordship, regarding item 2, Lordship, the documents were not placed properly because the petitioner had placed a lot of bills. Some of those bills have been placed because the construction were made by another department called PWD. Here now my learned friend has informed and he has talked to the officer also, Lordship. He will submit the documents and the bills, certain bills for item number 2. So Lordship, if item 1 and 2 can be taken up together, Lordship, that amount will also be included. I've been just informed by the officer that he'll try to include that amount also. There's an amount of 2,16,000.
2,70,000 has already been forwarded, so that remaining amount can also be tagged, and Lordship, the matter may be taken up together. I've been just informed, Lordship, by,
Why did you make a submission
no,
to them?
no, Lordship, the officer informed me some payments had been,
I put this specific question to you,
Lordship,
then it is the responsibility to have a document.
yes, Lordship.
Then only you have now realized that no. Why you
No.
don't make a submission
No,
just on the stroke
No,
of
no,
it,
Lordship,
the thin air, the look here, we have already made the payment.
no,
Why
Lordship,
did you
no,
make the submission?
what has happened was, Lordship,
No, you cannot make this type of submissions.
uh,
Did we see the recordings? Let us see the
no,
recordings.
no, no,
What did
Lordship,
you make?
no,
And if it is so, then we initiate the
no.
contempt proceedings for misleading the court.
no, Lordship.
No, Mr. Kohli, I think
No,
it's the high
Lordship, that-
time the lawyers also should be taken into task for making a false statement.
No,
before
Lordship,
us.
here I had.
You
not-
made a categorical submission that a payment has been made.
no,
Then I
Lordship.
said, if the payment was made, you must be having a document.
Yes,
It
Lordship.
cannot be paid by cash.
Yes.
Then he said, yes, documents will be there.
No, Lordship.
Then you said that, I said that, okay, produce it on
No, Lordship.
Wednesday. You said that Wednesday may not be possible because the payment was paid long time back.
Maybe, Lordship.
So
it's-
therefore, then I said, long time also, I had it on Wednesday, Friday.
Lordship here, no, Lordship will just, Lordship here, lot of, the petitioner had submitted a lot of bills, Lordship. Now, we are not a party in this matter, but and the petitioner has submitted past bills
I am
also.
not on
Yes,
that.
yes,
My
Lordship.
question is, whatever instructions you have to issue it. Because
Yes.
you see, Mr. Solia, if a contempt proceedings remains before this court pending for the last 7 years, it is shameful for this court.
Yes.
I'm telling you.
Lordship here.
With all things, I say it is shameful for this court that a contempt proceeding can be pending for 7 years for a meager amount of rupees 2,60,000 to be paid.
Plus, no, yes.
For you means that this court is not even inefficient enough to get an order complied of an order passed by this court.
Lordship here, Lordship
So
here.
Therefore, it is a very serious thing.
Lordship.
I
yes.
think we can prepone the amount, the case of the for item number 1 to Friday
Lordship.
and ask you to make the payment by then.
No, Lordship, I have just, Lordship will short.
Not have this for this year.
Lordship, Lordship, here here the petitioners have visited the officers. Lordship, we are not trying to
Why did you make that submission?
Lordship, the
I
office.
am not on the petitioner, whatever he has
Yes.
done. Why did you make the submission that the amount has been paid?
Because Lordship, those documents were not when the petitioner visited.
I'm
he-
not on that.
Yes.
Why did you make a submission that the amount has been paid?
So Lordship, because the officer was, I asked him.
But the officer said to you the payment was made.
I asked him why there is no instruction regarding item number 2. He's like, we do not have any documents. Perhaps the payment has already been made. That is why I asked the petitioner, because even I was not aware, Lordship.
And Mr. Mehdi has clearly said that no payment has been made.
Yes, Lordship. But
Well-
Lordship, the officer was also confused, Lordship. It was only, Lordship, we were not trying to mislead. We were only a little confused.
Full-fledged
Uh,
misleading.
No, Lordship, we were only confused, Lordship, because the documents which were furnished was regarding only contempt, item number 1. Item number 2, my learned friend, the officer has just informed me that he had not received. So I just asked my learned friend
Now,
to,
what is your instruction item number 2?
Lordship, item
For
number.
spoiling the 5 minutes of this court's time?
I apologize, Lordship.
50,000 on you.
I apologize, Lordship.
On you, Mr. Esulia.
I just wanted
Because
to
this court
clarify.
is again taking up, so
Lordship, I
50,000 on you.
I apologize, Lordship. That amount will also be included. I just.
I don't want that amount to be included of 50,000 cost upon you.
No, Lordship.
That would be, you have to deposit before the rate.
Lordship, I apologize, Lordship. There was some confusion, Lordship, because of which
You have spoiled 5 minutes of this
Lordship,
court's
I
time.
won't, Lordship, I apologize, Lordship, here, but it will be done, Lordship, here, we are trying every step, Lordship, to comply.
You are
with the-
trying for the last 7 years, 2,60,000 has not been paid.
No, Lordship,
Isn't it the shameful thing which has happened?
no, Lordship,
Which
here,
department is this?
this is the health, Lordship, steps were never completed. We are asked to assist the Lordship, and after that,
It has submitted on 15/5. This is 434, yes.
yes, Lordship, and those,
I directed and he has submitted.
yes.
Then on 15/6, you say, Solia, the learned for the submitted, some more time is required to give effect to the order dated so and so, in as much as the due budgetary provisions have already been
Yes,
made.
now the budgetary.
Now, this was 3 months back, 2 months back.
Lordship, yes.
Now, isn't it the most funniest thing in that earlier document also? You are making a budgetary provision But verification is not yet done.
Lordship, yes, no, yes, Lordship, that is, Lordship, because the documents.
You
are
are
not-
now trying to means play with the court
No,
for
no,
that.
no,
This official.
Lordship, here
Which
2009.
department is this family? Let's have the director. of
Lordship,
welfare.
no,
This is
no, Lordship.
like 16,000. Does it take so
No,
many
no,
years?
2,70,000 we have already processed and now we are about to pay. Now an additional 2 lakh, that is item number 2, that has, that those documents have been just produced, Lordship. Now we'll just add that. 2,70,000 has already been moved. Once those documents are verified from the Nagaon.
You are moved means read that document again.
Lordship, yes.
Read that document, earlier document which I put it as X. Read it.
Yes, yes,
Give it to him.
yes,
Read it loud.
yes. Uh,
The penultimate paragraph.
it may be mentioned here that the necessary budget provision for the,
One.
the documents pertaining to the matter consisting copies of order issued by the PWD concerned division, authority of transfer signed by the SDM and HO, Ding PHC so and so, which were submitted by the petitioner are enclosed herewith. You are requested to examine the submitted documents and submit necessary confirmation report urgently with regards to the work order and subsequent supply of the items so that the necessary steps can be taken for release of payment against the submitted bills. The report may be submitted by 30th of August 20.
Meaning thereby the verification is not yet done.
Once, yes.
Where is it mentioned that 2,70,000 has been verified?
No.
Tell me, where is it mentioned there? No, where is it mentioned there?
Yes, it is.
Don't make this type of submissions,
yes.
Mr. Solia, this type of here.
No,
Why there is no instructions on this? Put an instruction on this regard.
Lordship,
Okay,
yes.
item number 2, list the matter on Wednesday. Provide similar instruction as regards item number 2.
Lordship, yes, Lordship.
এইটো কি আছে? এইটো গুচাবহে গুচি এইটো নামটো কৰি দিলো দেখোন হ'ব এইটো এটা কৰি দিলে হৈ গৈছে
Lordship.
They're having it on Friday.
May I please, Your Lordship? 13.
Health and family, where is he gone? Yes, health and family. Does the Act of Registration of Births and Deaths Act permit putting two names?
Lordship, here.
Here in this case, you have put the name of the petitioner and another woman
Lordship.
name in the death certificate of one individual.
Yes, Lordship.
Is
Yes.
it permissible?
Uh,
That's the question.
Yes. Here, Lordship, we have communicated to the department, Lordship. Here, instructions are awaited, Lordship. We have received it, but no instructions have.
But do you have the power to? Does the health and family appear for register?
Yes, Lordship, we are the issuing attorney, but the verification is done by the DC usually, Lordship, but the registrar of death and birth certificate, that comes under our domain, Lordship. We are the issuing authority, but we are not the verifying authority.
You are the issuing authority of a death certificate.
Yes, and it comes under the DHS also, Lordship.
But how then you are putting two names?
Name of mother, name of father.
Page 23.
Name of wife.
This is under the signature of the Register of Health, Births and Deaths.
Yes, Lordship, that comes, yes,
Can you put two names?
Lordship. The name of two wives are there, Lordship.
You put,
Yes,
more
Lordship.
particularly when you are Hindu,
Yes, Your Honor.
Hindu.
Yes. Lordship, a short accommodation, Lordship, this is, I can receive the instruction within 1 day, Lordship.
I gave you time for last 3 months.
Yes, yes, Lordship, but it has been communicated, we have not received the, Lordship may fix it on Friday, Lordship, I'll get the appropriate, regarding this letter, because it'll come under our
No,
jurisdiction.
only issue is, can you issue a certificate having two names of two wives' names?
Yes, Lordship, and if we have under what authority,
Then
because,
there is a requirement for you to take action under section 15.
Lordship, because we are not the verifying authority, so the two names have been forwarded from somewhere, so I'll just get an instruction on what basis Lordship may fix
This
it.
was issued when?
This is
25.
date of the 3/7/20, yes.
Why haven't you filed an appeal under 25A?
Your Honor, actually, the point over here is actually while filing the representation and all, we had a lot of, I mean, we do not have a lot of time on that. So we were busy in filing the LIC policy and the following, where we made a lot of delay. The appropriate authority was, they were moving us to in different direction.
Certificate was issued on 8/7/2025.
This one.
You had to file an appeal under 25A. Why didn't you file it?
Because we thought we have to file in the writ petition at 22, 26 and all.
I make it clear, then you need to file an appeal and dismiss your petition.
No, Your Honor.
Yes. That cannot be a ground. The period is, there is an appellate remedy. The issue involved in the instant proceeding is the question of law on the aspect as to whether in a death certificate issued under Section 12 of the Registration of Births and Deaths Act 1969 in respect to a Hindu, in respect to a deceased who practiced Hindu religion, there can be names of two wives inserted in the death certificate. This court had issued notice on 24/6/2026. But till date, the respondents have not filed their affidavits. Mr. Alia submits that he will obtain the necessary instructions and file the affidavit within 2 weeks' time. List this matter on 9th of September 2026. In the meantime, the affidavit be filed on or before 7th of September. You file it.
Lordship.
For admission, huh?
On the last occasion, your
Yes,
lordship was,
Lordship, my senior is legging port number 18. So Lordship pending matter may be passed over for the time being.
What is this IA for?
I, আগে আজকে শেষ হয়ে যাবে। Well, the status of the inquiry has been there, madam. More to complaint.
This is on account of non-registration of an FIR.
No,
What is
my
the
lord,
case about?
your lordship was pleased to place the status of the inquiry, madam. A detailed inquiry took place, madam. The loans were, my lord.
No, today the matter has come to make CBIL a party. So we allow this IA.
এখন দিবা মোক।
There is an application for impleading the opposite party number 7 to the accompanying writ petition. Taking into account the order which has been passed by this court on 27/7/2026. It is the opinion of this court in the accompanying writ petition. It is the opinion of this court that the respondent opposite party number 7 is a necessary party to the in the accompanying writ petition. Accordingly, the opposite party number 7 is impleaded as the respondent number 7 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of party before the registry of this court. And the registry shall, on the basis of within 3 days, and the registry on the basis thereof shall make necessary correction in the cause title and update the same in the CIS. I stands disposed.
My,
Issue notice upon the newly impleaded respondent number 7. Steps be taken by way of speed post. Issue notice upon the newly impleaded respondent number 7, returnable on 25th of September 2026. Steps be taken by way of speed post during the course of within 2 days. Mr. Enda, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent number 6, have placed before this court an instruction.
report of the inquiry, my lord.
Isn't this an instruction to you? An instruction dated 8/8/2026, wherein it is mentioned that the complainant was examined and replies were received from the various banks. It was also mentioned that during the preliminary inquiry, it revealed that the allegations did not substantiate or found to be false as alleged by the complainant. And as such, no cognizable offense was disclosed. The said instruction is kept on record and marked with the letter X. A copy of the said instructions be supplied to the learned counsel appearing on behalf of the petitioner. During the court by Mr. N. Das, the learned counsel appearing on behalf of the respondent number 6.
Right video, my lord. Number.
The restaurant, he has filed an affidavit with completely new facts, my lord. We have to take insight.
When they filed the affidavit?
They filed on 14th only. August.
It has not come on record.
14th August, but all new facts, my lord. So we have to take insight, my lord.
It has been submitted that in pursuance to the order dated 29/7/2026, an affidavit has been filed by the respondent number three on 14/8/2026. However, the registry has not placed the said affidavit on record. Mr. G. N. Sahiwala, the learned senior counsel appearing on behalf of the petitioner, submits that various new facts have been brought on record by the respondent number three in the said affidavit. And as such, he would require some time to obtain the necessary instruction to his instructing counsel. And if so necessary, file an affidavit in reply. A rejoinder affidavit. Taking into account the above, list this matter on 18th of September 2026. In the meantime, the reply affidavit be filed.
As for the last order, my lord, 17/6, Hoshi directed the government to file affidavit. And today is fixed for my lord for disposal.
What is the matter about?
Well, the affidavit was drafted and it was sent to the DC, my lord, but somehow it could not be filed, my lord. The issue is relating to issuance of caste certificate to the petitioner, my lord. Lordship may grant me 1 week time, my lord. I'll bring it. Otherwise, we have sent the copy for vetting, my lord.
Affidavit has not been filed.
Well, it was prepared and it was sent to the district commissioner for doing the needful, my lord. Somehow, my lord, it is missed, my lord. We could not find it, my lord. Kindly give us 1 week time, my lord. We'll bring it on record, my lord.
Why the DC filing?
And my lord,
Why you are not filing? You are the main person.
No.
Why?
DC did not, my lord, DC and the tribal Sangha, my lord, they did not, my lord. The tribal Sangha did not recommend and DC did not issue the certificate, my lord. I being tribal authority or my lord, the state level scrutiny committee, our things comes later, my lord. If it is
Understood. Yeah, the main question is to whether the Ravi community will come within the ambit of a STP.
thing is that DC
Use
has
the
been
mic,
rejected.
there's a mic out there.
My lord, the thing is that unless DC, my lord, on what ground they have rejected, that is, we have to know, my lord. Without knowing,
We'll look into it. But my question is, isn't your requirement also to say whether the Ravi community would be? Yes, on facts, the DC may say that he does not belong to the Ravi community. But the first and foremost, as to whether the Ravi community will be an STP in Assam. See the prayer which has been made.
my lord,
Inaction, Moparin, respond number 2 in refusing to issue the caste certificate in favor of the petitioner and all other eligible members of Ravi communities as STP plains. Now, now whether the Ravi community in Assam would be an STP plain, that has to be on the basis of the order which has been passed by the president.
presidential order.
Presidential order under 342. So therefore, whether it is included or not, it is for you to say. the DC may say that in these facts we have not issued. He may say on the factual aspect, but whether he is entitled, whether the Ravi community will be entitled or not, what is your stand? You need to file the affidavit because without that, can the DC tomorrow say that the Ravi community and would you accept it? Can you? You would.
No, I cannot. It will go by the president order.
Then you have to come up with that. Mr. Dina, the learned counsel who represents the respondent number 2 and 3 submits that the affidavit has been prepared and would be filed by the next week. This court has put a specific question upon the query upon Mr. Adhor, the learned standing counsel of the Tribal Affairs Department of the government of Assam, as to whether the Ravi community would fall within the, what's the name of the order? Schedule tribes, Assam scheduled tribes, or the constitution, what is the name?
ST Amendment Act
No,
1970.
no.
Presidential order of 1951.
Pachari community, my lord, was brought.
In terms with the scheduled caste / scheduled tribes under the constitution scheduled caste order 1950, no, it will be the scheduled tribes under the constitution bracket scheduled tribes order 1950. That's the name, I suppose.
Yes, ma'am. It's correct. 50 or 50.
In the constitution. The scheduled caste and scheduled tribes order নাম তো কি আছে? Scheduled caste and scheduled tribes order 1950. What is the name, Mr. Dhar?
That's what I'm giving, ma'am.
It should be in your tip of a tongue. Taking into account that your bread and butter comes from the tribal department. I'd have understood if for Mr. Nath may not be knowing it, but for you? Because his case is, you have to understand, Pachari is brought within the scheduled tribes. His case is that Ravi is a part of the Kachari tribe. So it is you who have to come, not him.
That is why, my lord, he has to establish his case that Ravi is a part of scheduled tribes community which belongs to my lord Kachari. Then it has to be referred to caste scrutiny committee. They will verify and individually, my lord, not as a community, my lord.
No. This is a larger issue as to whether the Ravi community would be a part of the Kachari community or not, Kachari tribe. That is the issue.
That is the, but in fact, there are in Sibsagar district, in that particular area, there are some Ravi community persons, they belong to OBC. And they claim to be belonging to Ahom community. So some are Ahom OBC and some are claiming to be ST. That is, there is a factual, the ground level information is there on the OBC.
So you as a district commissioner you have a very limited scope.
Logic.
Because the Kachari tribe is a tribe which is not only in the state of, in the district of Sibsagar. The Kachari tribe is Pan Assam. So therefore, it is for the government to say so.
Logic.
And the government is not doing it. Have you got the name?
Well, this is Constitution Schedule Tribes, Order 1951.
1951, this is it.
Constitution Scheduled Tribe Order 1950. 1950. Lordship,
As to
can we
whether
get
the Ravi community, so this court has put a specific query upon Mr. Ardhor, the learned standing counsel of the Tribal Affairs Department of the Government of Assam, as to what is the stand of the Government of Assam in respect to the issue as to whether the Ravi community would be considered as a subtribe of the Kachari tribe, which is an enlisted tribe in the constitution, it will come to the here, of 1951. Mr. Ardhor, the learned standing counsel, submits that an affidavit would be filed on behalf of the said department within 2 weeks. List this matter on 11th of September 2026. The affidavits on behalf of the respondents be filed on or before 7th of September 2026.
And I will have the liberty, my lord.
We'll see. First, let them do it. If they say yes, then
My lord.
Matter relates to non-payment of the grant, my lord, to the children home. Petitioner Society was running the children home from 1/7/2012, my lord, to 1/12/2014. So, my lord, in between, they have released, my lord, two payments.
what happened after the order passed on 27/2/2026?
My lord, we have filed the affidavit, lordship. Lordship will find paragraph 6 as is 99, my lord.
299,
Only 99, my lord.
219, 229. Not 99, 229.
Our affidavit, my lord.
229.
229. ऐसे की बात।
So at paragraph number 6,
Yes.
they say that you have received 392,
Yes.
690, and for the period from 1/4/2014 to 31/11/2014, you have not submitted the reimbursement proposal along with the original bill, vouchers, SOE, etc. against the expenditure made for the welfare of the children from so and to so and so. And you see against the previous fund utilization certificate you have not. If you submit, they will consider.
Yes, my
No, my lord, a utility certificate we have submitted. But
They say
Yes.
you have not. Have you submitted these? The original voucher,
lord,
SOE, etc.
my lord, what happened, my lord? Actually, PAP committee, project approval committee, my lord, project approval board used to release the fund as per the number of students. There is a guideline, my lord. Earlier, my lord, This was the guideline up to 2014. In 14, there was a revised guidelines issued by the ICDS. Revised guideline I have annexed, Earlier, this was the guideline they used to follow. There are different heads regarding recurring grants and non-recurring grants. So, they have earlier they have paid only.
My question is, Mr. Scott, kindly come to page 233.
Yes, I have seen.
They say that this, if you, the original bill, voucher, SOE, etc., against the expenditure made for the welfare of the children from so and so and UC against the so and so.
Yes.
Have you submitted these?
I have submitted, but these are not required to be submitted according to them, my lord. After filing this
Did you
affidavit.
get the amount, earlier amounts without those?
Yes, my lord. Yes, after release of those amount, I have submitted the utility certificate. I have stated in my.
Utility certificate is different. I'm not on that.
Yes.
UC is okay. You have submitted for this. But what about the others? The
Others,
original
my
bill,
lord.
vouchers, SOE?
Others are not required to be submitted because there is a mechanism, my lord. As per these guidelines, PEP committee approved the grants. I have annexed the PEP committee report also here in the petition. After release of funds, I have to submit the utility certificate, and I have submitted that. So bills.
But you submitted the utility certificate prior to that?
Yes. No. After release of that fund.
Did you get the money for 2014?
No.
So then obviously you did not submit the utility.
No, my lord. Only after release of funds, I have to submit the utility certificate.
No, he is asking for utility against previous funds released.
Yes, previous funds I have submitted. I have stated in paragraph 9 of my petition, my lord. Utility certificate, my lord. Copy I have, my lord, but these copies we have submitted, my lord, already.
We do one thing.
My lord.
We can close it on the basis of this paragraph and direct them to consider your case based upon the standing instructions which were there, guidelines at that point of time. What are the documents?
Yes.
And to do the needful.
And my lord, latter part, there's a revised guidelines that I have annexed, my lord.
Why should we go into that?
Revised
We
Yes.
are only till 2014.
14,
Yes. So.
No, our case is only limited to 30/11/2014.
yes.
Thereafter, I'm not going to look into it.
Yes, my lord. 31st 12 2014. So, my lord, April 2014, revised guidelines comes.
Understood. So as per the revised guidelines, what is necessary, you submit.
Yes,
We
madam.
will consider.
Yes.
140.
Heard Mr. N.K. Kulita, the learned counsel, appearing on behalf of the petitioner.
আপনি PEP committee report to চাবচোন এই PEP committee report টো আছে আপুনি অকল utility লিখি
তেনেহলে এইটো কেলে লিখিছে
Union. Ms. Yudas appears, social welfare.
we appear, madam.
Ms. Yuda, the learned additional senior government advocate, appears for respondent number 2 to 6. The present petition has been filed by the petitioner, seeking directions upon the respondents to release the amount of rupees 42,29,100, which as per the petitioner was payable from the period with effect from 1/7/2012 to 1/12/2014. And further seeking certain directions for constitution of an inquiry. to inquire into, okay, of an inquiry committee to inquire into the matters regarding the existence of two children home in the name of Vikalanga Kalyan Kendra, Pohumoria, Lokhimpur, and the approval by the meeting of the project approval board under the ICPS or ICDS?
ICDS, my lord.
IC?
ICDS.
ICDS for release of the grant in the name of the two children's home. When the matter was listed before this court on
I'm sorry, my lord.
27
It is ICPS.
when the matter was listed before this court on 27/2/2026, this court duly had taken note of that the government of India had already sanctioned an amount of rupees 10 crores 80 lakhs to run the ICPS project in the state for the financial year 2013-14. But the state government had released only an amount of rupees 624,56,000 in installments. It is also seen that for the financial year 2014-15, the central government had sanctioned an amount of rupees 10 crores, but the state government had only released an amount of rupees 683,98,000. It was also seen from the affidavit so filed by the Director of Social Welfare that the state government had not been releasing certain funds which the central government had already sanctioned. Taking into account, this court directed the Commissioner and Secretary to the Government of Assam Social Welfare Department to respond why the amount which have been sanctioned by the central government have not made way to run the ICPS projects in the state by allocating funds which have been sanctioned by the central government. In pursuance thereto, an affidavit was filed by the respondent number 2. Wherein a communication issued by the respondent number 4, that is the Director of Social Welfare, that is the Member Secretary State Child Protection Society Assam, was enclosed, wherein it was informed that the State Child Protection Society Assam had received all funds from the state government which were sanctioned by the Government of India in the financial year 2013-14 and 2014-15. Paragraph 6 of the said affidavit is of relevance, is 232. And as such, the same is reproduced here in under. From a perusal of the above quoted paragraph, it is seen that the petitioner organization have already received an amount of rupees 3,92,250 for the period from 1/7/2012 to 31/3/2013, and further an amount of rupees 6,90,750 for the period from 1/4/2013 to 31/3/2014. However, in respect to the claim for the period from 1/4/2014 to 31/11/2014, the petitioner organization had not submitted the reimbursement proposal along with the original bill, vouchers, S, O to Huru, E to capital, etc. against the expenditure made for the welfare of the children for the period from 1/4/2014 to 31/11/2014, 30/11/2014. It is also alleged that the UC against the previous funds released have also not been submitted by the petitioner. It is also of relevance to take note of that the respondent number 2 have also given an assurance before this court by way of an affidavit at paragraph number 6 that in the circumstance the petitioner submits the documents, the reimbursement proposal along with necessary documents for the period of from 1/4/2014 to 30/11/2014. The respondent number 2 could consider to release the funds as admissible. So taking into account the above, it is the opinion of Mr. N.K. Kulta, the learned counsel appearing on behalf of the petitioner submits that there was no requirement of submission of the original bill, vouchers, SOE, etc. as per the guidelines issued by the State Child Protection Society, Assam. These guidelines were made effective from 1/4/2014.
Oh, my lord, this was earlier, my lord.
So why we are concerned with this?
Need to know.
We are concerned from 1/4/2014.
Revised, I have annexed with the petition, my lord.
Where is it?
Revised guideline at page 31.
So what is the guidelines for?
The lordship will find at page 36. 35 onwards, my lord. I have submitted the earlier because earlier part, my lord, connected with that
No,
guideline.
it cannot be. For this period is different.
Yes, 1/4/14,
14.
this will be applicable, revised.
It will encult to decide. Taking into account the stand at paragraph number 6 of the affidavit, as quoted above, this court therefore disposes of the instant writ petition with the following observations and directions. As the petitioner have already received the amounts for the period of for the periods that is from 1/7/2012 to 31/3/2013 and from 1/4/2013 to 31/3/2014. There shall be no necessity further for the respondents to make any further payment for that period.
My lord, in that regard, my submission was that payment was made lump sum payment, my lord. Other recurring expenditure, non-recurring expenditure, house rent, those were not paid at that time. So my claim regarding that period was also dear, my lord. That is why I have submitted that earlier guideline, my lord. As per earlier guideline, house rent, water, recurring expenditure, other, my lord, books, televisions.
Any more further submission?
No, my lord, no.
So why you are not saying, when I was referring to only 1/4/2014 to so and so, why we are not saying that you have certain objection as regards the earlier amount?
That is why I have submitted the earlier, my lord.
Merely by submitting the guidelines, can I understand that this is your submission? You have to say that the amount which have been given for those periods is not satisfactory. That you
Yes, my
are
lord.
satisfied. Where is your submission to that?
I have stated that recurring expenditures and non-recurring expenditures, my lord.
In the earlier period, did you say that?
No.
That is why.
Any further submission, Mr. N.K.?
No, my lord, no, no, no.
No,
We dismiss your writ petition, however we dismiss it like this.
no reply also filed, my lord, controverting the
It's okay.
statement, my lord.
Taking into account the above. Mr. N.K. Kulter, the learned counsel appearing on behalf of the petitioner submits that those payments of rupees 3,92,250 and rupees 6,90,750 have been paid to the petitioner for the period from 1/7/2012 to 31/3/2013 and 1/4/2013 to 31/3/2014. But the said payments have not been made in accordance with the prevailing guidelines. And as such, the petitioner was further entitled to further amounts. The learned counsel further submitted that in respect to the period from 1/4/2014 to 31/11/2014, the petitioner is not required to submit the original bill, vouchers, SOE, etc. against the expenditure made, inasmuch as the guidelines, the revised guidelines which were made effective from 1/4/2014 did not require so. The learned counsel further submitted that the the utilization certificate have already been provided for the previous funds released. Taking into account the above submissions, it is the opinion of this court that if the petitioner disputes the amount of its entitlement during the period that is from 1/7/2012 to 31/3/2013 and from 1/4/2013 to 31/3/2014, the said amounts can only be the petitioner. This court cannot decide the same. And in that regard, the petitioner would have to approach the competent court of civil jurisdiction. Insofar as the claims for the period from 1/4/2014 to 31/11/2014, 30/11/2014, it is the opinion of this court that taking into account that the respondents, number two, have given an assurance that the petitioner's claim would be considered if the necessary documents are being submitted. This court is of the opinion that appropriate directions can be issued, thereby granting the liberty to submit the necessary documents, and thereupon the respondent authorities may release the amount. Accordingly, the writ petition therefore stands disposed of with the following observations and directions. Insofar as the claim of the petitioner for the period from 1/7/2012 to 31/3/2013 and for the period from 1/4/2013 to 31/3/2014, if the petitioner, as the petitioner disputes its entitlement and claims a further amount, the same can be only adjudicated before a competent court of civil jurisdiction wherein evidence have to be led. Under such circumstances, this court is not inclined to direct the respondent authorities to make further payments in respect to the period from so-and-so to so-and-so and so-and-so, so-and-so, inasmuch as it is as per the assessment of the respondent authorities that that the petitioner is entitled to only to the amount of rupees so-and-so and so-and-so for the above two periods respectively. Be that as it may, the petitioner would be at liberty to approach the competent court of civil jurisdiction if so advised. Number 2. Insofar as the claim of the petitioner for the period from 1/4/2014 to 30/11/2014, the petitioner is granted the liberty to submit the necessary documents as per the requirement set out by the guidelines. And if such documents are submitted, the respondent number 2 is directed to consider the entitlement of the petitioner and make payment, and if upon verification it is found that the petitioner is entitled to any amount, the said amount be paid to the petitioner within a period of 6 weeks, within a period of 3 months from the date of submission of the documents, complete set of documents, from the date of submission of the complete set of documents as required as per the guidelines. This court further observes that in the circumstances of the petition, if it is found upon verification that the petitioner is not entitled to any amount or is entitled to amount less than what has been claimed by the petitioner, the respondent number 2 shall duly inform the petitioner by issuing a communication as regards the entitlement. The said communication be also issued within a period of 3 months from the date of submission of the documents in all aspects. Next, complete in all aspects. Next, the said documents be submitted by the petitioner along with a certified copy of the present judgment and order to the respondent number 2.
My lord, the lordship has directed the petitioner to approach the competent court, my lord. In that effect, my lord, my lord, the limitation period, lordship may, that part may consider, my lord. Because otherwise, my lord, it is the.
Did you receive the money?
My lord, it is 2014 and 13.
Then how can I extend the limitation?
And my lord, this petition is pending, my lord. So, my lord, now lordship is the directing. So, my lord, lordship make an observation, my lord, to that effect.
Okay. It is first to taking into account that the petitioner had been bona fidely litigating before this court. Opinion of this court that the period during the pendency of the petition from so and so till date be excluded while computing the period of limitation.
Please, my lords.
Yes.
My lords had directed the state to file an affidavit on 20th August on the last order. There is an affidavit that I have received a copy of.
Okay. What did it say?
Well, my lords, it's unfortunate, but they seem to backtrack on something that is recorded by this honorable court in the order dated 30th of April. And now what is being said is that, and I'm reading the relevant end part of para 3, that the Assam, as on today, the aforementioned Assam Victim Compensation Scheme 2019 is the only scheme in force in the state of Assam, which covers the issue relating to payment of compensation to acid attack victim. The issue raised by the petitioner regarding the proposed cost, etc., for further treatment of the petitioner is under consideration of the authorities as the same is not covered by the scheme of 2019. My lords, this matter now since April. In April, my lords, if I can just go back to that order of April, 30th April 2019, where my lords has recorded in para 4 and 5. No, no. Where's the principle? The word principle was written. My notes had in para 7 and 8 of the order dated 30th April, that's the next one. Had in order, when I had drawn my lord's attention to the relevant judgments and the extracts of which are reproduced in the order dated 30th April, the Nipun Saxena judgment, and I'll take my lords through that, specifically states that this is the minimum, but as best and the best practice cannot fall below this. However, if it is so required, the state can always provide for more. Therefore, my lords, in para 7 of the 30th April order, the court has recorded, having regard to the aforesaid authoritative pronouncements and considering the peculiar facts of the present case, this court is of the considered view that the right of the victim to receive adequate medical care cannot be constrained by technical or financial limitations, particularly when a competent medical opinion indicates a reasonable possibility of improvement in vision. The obligation of the state in such circumstances is not merely compensatory, but extends to ensuring meaningful rehabilitation. And then the recommendation that this should be done at the Hyderabad hospital, where she has been taking treatment, previous surgeries were performed there, that it is advisable that it continues there in view of the benefit of medical continuity. Now, my lords, may come to the order dated 12th May. I'm reading para 2 from the middle, where Mr. D. Nath, learned senior government advocate, on instructions, submits that while the financial disbursement may be routed through State Legal Service Authority / DLSA, in accordance with the applicable framework, the necessary funds for the same would ultimately have to be made available by the state government. He
But
further
madam, just tell me whether it is the opinion of Sri Shankardev Netraloy that she should take the medical the what do you call the treatment only from Hyderabad.
Please, my lord. My
is
lord,
it the opinion of the Sri Shankardev Netraloy that the petitioner should avail the treatment only at Hyderabad?
my lord, she has already undergone a few surgeries with regard to the right eye, where the vision has been considerably impaired. And the same, she wishes to, the petitioner wishes to do the next corneal grafting also at the Hyderabad. It's a specialized hospital. It's called the Apollo Cornea Hospital. There is a Dr. Fogla under whose treatment she has been since the time of this acid attack on her. And
But madam, one has to understand, this has to be based upon, has to have the backing of a medical opinion.
Yes,
that
yes.
it is required that she continues the treatment there. It cannot be on the basis of this court's wisdom or my line coordinate bench wisdom that she should go there. If there is a medical opinion by Sankardev Netraloy where she can otherwise undergo her treatment to the effect that look here, this treatment, if it is done there, would be the best, and we are not in a position to do it, then obviously this court would have then compelled the state to do it. But without that opinion, would it be proper on the part of this court to exercise 2 to 6 when it is the stand of the respondent state? Yes, Mr. Nath had made that submission. That is what in the morning also, madam, the problem is the government councils make submissions in thin air. Today, one government council made a submission, we have already paid certain amount. Then later on, after 1 hour, he comes and no, we have not paid any amount. Now, this is the problem. So therefore, I asked them to bring it on affidavit on the last occasion, because if they don't file an affidavit, they resile from what they said. This is the problem, madam.
My
So
lords is right.
therefore, if we can get an opinion from Sankardev Natraloy, which I think is the premier institution for eye in Assam, that there, if she continues her treatment out there or gets state, it is the better option. And they don't have similar things to do out here. I think this is the best we can obviously direct on the basis there. Give me some handle, I will direct it.
Please, my lords,
Whether they mind or not, that is not our concern. Whether they have to apply, give the amount, whatever is required. But give me a handle for that, madam.
I appreciate what is following from my lords. My lords, in my affidavit, there is an annexure B at page 20, what is the page 29, where the Shankar, at page 68, I'm sorry, annexure B at page 68, where the Shankardev Netralaya has said that yes, this particular treatment is required. My affidavit dated 11th May. There is a.
We have a running page, madam, here.
I'm so sorry.
When did you file
Affidavit
it?
dated 11th May. 11th May 2026.
Okay. Page 50.
Page 68, my lords. Of that, there is an annexure B which has the
We have it. It is the patient reviewed right eye. Repeat right eye corneal grafting can be done to attempt vision. Possibility of graft failure explained to so and so. Patients seem to have understood.
My lords, it is after that. Please, my lords, this is what was recommended, medically recommended. Prior to this also, all these surgeries she has undertaken in Hyderabad and in a specialized hospital. And therefore, the submission was made that since they have recommended that one more corneal grafting should be attempted in the right eye, that the same may also be done at the hospital, which has for the last so many years been attending to her eyes. And she has been in communication with them. So if this surgery may also be allowed to be conducted, they have in the past paid. And we
Madam, earlier surgeries, was those surgeries done with the help of the state?
Yes, the state has reimbursed for every surgery done at Hyderabad, including all ancillary expenses with a companion for her travel, boarding, lodging, surgery. Everything has been.
In fact, Malad, my instruction is that up to the maximum compensation payable under the scheme.
That's okay.
That has
No,
covered.
but
That has covered.
whatever compensation is given in the scheme, it's okay. You have paid 8 lakhs, whatever may be, you have paid. I'm not on that. But you have earlier provided this, the petitioner all the medical expenses at Hyderabad. Now, if there is a requirement for that opinion, that there is an opinion, repeat right eye corneal grafting can be done to attempt vision improvement, possibility of graft failure explained to the patient. Now the question is, if she wants to go there in view of this, you need to provide. But don't you think that you can also consider having some other opinion also, or take it up something? But if it is a requirement to do so,
but in fact,
if it is a requirement and taking into account that the state had already done it earlier for him, for the petitioner, so therefore it is a requirement that you have done it there, why not here? Yes, I'm not saying that somebody may face on account of an SC attack, there might be a facial disfigurement and all. Yes, for the purpose of doing the necessary cosmetic plastic surgery and all, you may have to do it. I'm not saying that you need to do for something like a cosmetic, a very high-end cosmetic surgery. This is a case of Article 21. So therefore, if this is a requirement for the purpose of improving her eye, then it is a necessity as you have already done for earlier for this petitioner. Now, for that, if you need another opinion as to whether it is something to that effect, because it seems what is mentioned is possibility of graft failure may also happen. Now, whether it is possible to do it here in Assam, that this can be done, All these things you need to take a consideration. Now, this was a consideration which was to be taken as far back as on 12/5/2026. The learned coordinate bench has passed an order. So look into it. Why does it take it for 3 months for that? You have it out there.
Well, in fact,
Where the state of Assam must
What
be
is the
busy
total
with the floods
350?
and all.
well, in fact, that is what my submission would be, Manoj, we have already taken up, the authorities have already taken up the matter with the health department, Manoj. The health department, they have many Manoj facilities are there. So they have already taken up the matter with the health department, whether the health department has some mechanism to assist her, to give her some, provide her some benefit for going outside, or they will suggest some, they have some mechanism, Manoj. That is under consideration. That is why we have stated in the affidavit that they have already taken up the matter, Manoj.
How much time do you take? How much time do you require?
Manoj, the health department has been consulted, although the health department is a party here, Manoj. It's a respondent herein. From the home department, we have filed the affidavit, and they have already taken up it.
Home is not going to decide that. It is the health department who has to decide it.
No, this scheme, victim compensation scheme has been
Provide,
promulgated.
you will provide the funds.
Manoj,
How it is to be carried out, it has to be done by the health.
expertise with them. That is true. They have already taken up the matter with health, and there are discussions, Manoj. In fact, the mechanism, Lordship, kindly appreciate, Manoj.
When we get a positive answer.
Manoj, what I would like to submit, Manoj, kindly see, Manoj, these are situations, Manoj, that has to be taken under a particular scheme of the government. Ultimately, Manoj, these are situations, new situations coming up, Manoj.
And why did you, apart from the other, why did you provide the petitioner health out there earlier in Hyderabad?
To the extent it covered under the scheme, Manoj, that has already been paid. There is no difficulty.
You mean to say the earlier expenses were only up to 8 lakhs? Or is it something?
No, that is what my instruction is, that the maximum.
No, I am not Mr.
Lordship.
I'm not on instruction. What is your stand in your affidavit?
That maximum 8 lakhs, which is permissible as on today.
No, did you spend the only 8 lakhs for the purpose of the petitioner's earlier treatment?
My instruction is
and
that.
did you pay the petitioner in addition to that certain ex gratia?
My instruction as on today from the district level, the legal services authority is that from time to time, various amounts have been released, and that amount has been released under the scheme only.
Amount is released. You see, these amounts which are being released are released as ex gratia. Now, are you using that ex gratia for the purpose of treatment? My question is that.
But I have not. In fact, I have tried to see, Manoj, that whether treatment cost is different, compensation is different.
That is that you cannot now come up with you are trying to make a different case altogether. On one hand, you are saying that look here, 8 lakhs I have paid her. Last occasion I remember, we have already paid her 8 lakhs. Now it is a case out here that look here, 8 lakhs is there. I have used this 8 lakhs for the purpose of providing her treatment at Hyderabad. Is it your case there?
But the record.
Or is it more than that?
No. As on today, whatever my instruction is, in 2016, 2 lakhs was paid. In 2017, 1 lakh. And in 2019, 5 lakhs was paid to her.
This is 8 lakhs.
8 lakhs.
So you have paid her.
Yes, Manoj.
My question is, who bear the expenditure in Hyderabad?
It is the petitioner, Manoj. Petitioner will be in a better position to say, because my instruction
No,
is to that extent only.
You will be obviously having the documents you have, if you have done it or not. That's the question.
Apart from
my question to madam at that point of time was that, who was sponsoring her treatment at Hyderabad? Now, if you were sponsoring her treatment at Hyderabad and the petitioner did not pay a single penny, and in addition to that, rupees 8 lakhs have been given, then what stops you now to provide that if this is a necessity?
I do understand, Manoj, the query of the Honorable Court, but my instruction is very limited to the extent that we have paid 8 lakhs rupees as per the scheme, the maximum limit we have paid.
So are you saying that you did not provide the petitioner the medical treatment facilities in Hyderabad?
No, I'm not saying that.
No, Mr. Nath, are you not appearing in this matter for a long time? This is the simple question. Where you for the last 2016 onwards, the incident happened. We are in 2026 today. Where this was the state involved in providing treatment at Hyderabad for a petitioner, apart from payment of the ex gratia?
As per the statement made by the petitioner, they said that it is being paid by the state. I take it that as, my lord, but
If you take it, then why I'm trying to make the confusion out here to the effect that
Because-
look here,
because
we
there
have
is
only
no-
paid this, I don't know others.
so there is no record since 2019. My lord, from 2019 till 2025, the matter was not listed for 6 years. My lord, it was not listed, my lord. And in fact, the records whatever I have received in the month of after
When was her last surgery?
after the matter was listed in the month of April, I appeared in the matter, my lord, and whatever instructions I have
You
received,
do one thing,
my lord.
you provide information, two informations which I, whether, because this document does not, says only that there is a requirement of a graft treatment.
Lordship.
Now, the petitioner had all along had that surgery out there in Hyderabad and all. Now, the question is whether, you see, after all, one has to also understand that whether such a surgery is possible in Assam or not. If it is not
That
possible,
information will guide.
there is a different question. If it is possible, because we are proud of this institution of Sankardev Netraloy, we are proud of it. So whether it is permissible, okay, they can go ahead and do it. Because if that be so, that is one aspect. Number two, were you providing the treatment expenses at Hyderabad apart from the ex gratia? If you were providing, then what stops you from providing this? So take a call on that
My lord.
and provide us a detail on this on the next date.
My lord. Lordship.
My lords, may I just make one submission, my lords? My lords, the last surgery in Hyderabad was in 2019. Detailed accounts were submitted. There was a nodal person in the ministry. She has submitted all the bills. Full reimbursement was granted. And when this matter was taken up again
Whether
on
these
it,
reimbursement, madam, had anything to do with the ex gratia?
no, my lords, that was separate. The 8 lakhs was separate. My lords, the second submission I want to make is that with regards to the continuity of being under a particular doctor is something that is, will be of, there is a certain faith and trust that develops. It is not to say that the medical facilities in a particular state are not of the best quality available. But the state had never at that point raised this issue or concern even once. She traveled, they reimbursed. That is a specialized hospital. It
Madam,
concerns a vital organ of her.
Understood,
Well,
madam.
just one more submission, one
No,
more
only
submission.
one thing I need to mention one thing. There are many things one need to think about. One is particularly is, see, at the end of the day, it is the state who will be paying it. State
Yes.
paying for one person is okay.
Yes.
But it cannot be for all. So that is why something has to be brought in by which it has to be shown that there is such facilities are not available, or there Sankardev Netraloy says that yes, if it is done in that hospital, then we can push it out there. But otherwise, to impose the state becomes a difficulty. Yes,
My lords, if I may
that-
very
otherwise
respectfully
it is
submit.
okay.
My lords, if I may very
Because
respectfully
tomorrow
submit.
this will become an issue in all other cases. It becomes a very difficult proposition.
My lords, if I may very respectfully submit, the amount of money that she is requesting and seeking from the state is actually, as per state funds, only 3,50,000 is required for this surgery. It's not some exorbitant amount as far as the state
Madam,
is
it is not a
concerned.
question. If it is 25,000 also, it's not a question. I'm not
No,
on
my
that.
lords.
I'm
My
not on
lords,
the
then
3,50,000 or
I
anything.
bow
I'm not the
down.
question.
I bow down.
But the moment it is required that in every case, everybody will go there, then it may open up in many cases, it will have an impact.
My lords
So
is right. My
therefore,
lords,
it
there
becomes
are
very difficult sometimes to pass a direction under 226, thereby obligating the state to do certain things when it can be done here. Yes, if we get something from Sankardev Dental that she gets a treatment out there, that area is better. It's a way
Please, my
we
lords.
can very well proceed with that in that
Please.
reality.
Please, my lords, I'll ask her also to
Once
meet the
she gets
doctor
that
and see.
opinion, then we can push
Yes.
it out. Because
I
then it will be
appreciate.
better than, it becomes one in a, in one, yes, madam, 1 in a 10 million case.
Therefore, I'm keeping mum right now.
Because otherwise in all cases it may happen.
My lords is right. My lords, I would like my lord at the appropriate stage to take my lords through the legal submission affidavit document also that I'm placing on record, a copy of which was given on the last date to the state. My lords, so what is the obligation of the state? One, my lords, here is the state taking steps to ensure that these kind of crimes are not prevented? Let us look at the NCRB data pertaining to the state of Assam. The state of Assam is also here under I have a right to compensation for failure to protect. I was hoping that the state's affidavit is simply saying under consideration. If somebody needs a surgery and this person who is making this claim today is actually a member of the bar whose entire personal and professional life was jeopardized because of a gender-based crime, one would have expected a little bit more generosity of spirit from the state at this juncture, which doesn't seem to be forthcoming despite the court on repeated occasions pointing this out. My lords, I can take my lords through judgments, both of the Supreme Court and of different high courts across the country under Article 226. Under Article 21, high courts have held this will not be a constraint if it is a case of acid attack. The state will pay for full medical treatment. What that medical treatment will entail in terms of money, I think the citizen here has the first claim on the funds of the state. It is very unfortunate that this
Madam,
affidavit doesn't say anything.
tomorrow, this graft treatment can be only done in United States. What do you say then?
My lords, if I may just, this country.
It is also
flew-
available here, but it says the graft treatment and the person concerned says that let us get it done in United States.
My lords, with all due respect, that extreme example, it's unfortunate that perhaps leaders get those treatments and not the citizens.
No, so therefore, one needs to have something. Yes, if these facilities are not available, then only things can be there. Yes, if
I respect what is
comes up with this and says that if she continues with her treatment or does it with that particular doctor in that particular institute, it would be better. Then we can push it out here and direct them to do it.
My lords, we will also explore this. We will also explore this, but for the state to say.
And then we will take it up. When do you want to file? You bring it on record, that document. Once you bring it, and then I put it to them, and they will have to do it.
My lords, I will ask the doctor.
Madam, what I need to do is bring you within an exception and give you the benefit. But give me the handle to bring you within that exception.
My lords, to the best of my understanding, to go to a doctor and say, please write here that you are not the best. Somebody else can do it better.
Out here.
It would be difficult. It would be difficult.
They may very well say that the best person will be this, so and so, who can?
My lords, it is about the continuity of her treatment. My lord, this onus, my lord, should not place on her. It is a paltry sum of 3,50,000.
I have a difficulty in passing that order, madam.
Let me explore it. Let me explore it. But let the state.
It's a very difficult.
But let the state also come with instructions that they will not pay for medical treatment over and above this. This is
madam, if the state comes with such instructions also, it doesn't matter. If you are entitled, your treatment needs to be done at Hyderabad, it will be done, provided you give me a handle for that. Only that.
My lords, I will also make efforts, but I'm sure the state can also, since it's under consideration, the paltry sum of 3,50,000 will not even be noticed.
It's not a question of, madam, it's not a 3,50,000. It may be in many cases. Allow us to put an exception and give you the benefit to the petition. The only thing is, allow me to do that. But give me some handle for that.
At the end of the day, my lord, it is a policy for the state, my lord. Ultimately, it's a policy for the state. So they have to work on that, my lord.
My lords, on the policy on the next hearing.
I'll pass the order too.
My lords, on the policy. On the
Lordship,
policy on the next hearing,
Madam,
I
actually,
will.
we are, I'm running 15 minutes past the
I'm so
recess time.
sorry. I'm extremely sorry. My apologies. My
I'll
apologies.
pass the order at 2. Yes, government, what affidavit you filed? Show me.
What's item 6? 18. What's item
You
8?
filed an affidavit.
Yes, Your Lordship.
Where is that? Heard Miss V. Grover, the learned counsel appearing on behalf of the petitioner. Mr. D. Nath appears on behalf of the respondent number 1 and 4. Madam, you are appearing for?
Respond number 7.
Also appears for respondent number 7. Pursuant to the order passed by this court on 12/5/2026 and
30th April, my lords.
12/5/2026, as well as the order passed by this court on 12/8/2026, an affidavit has been filed by the respondent numbers 1 and 4, wherein it is mentioned at paragraph number 3 that the issue raised by the petitioner regarding the further treatment of the petitioner at Hyderabad is under the consideration of the authorities on the ground that it is not covered under the Assam Victims Compensation Scheme 2019. Full stop. This court finds it relevant to take note of that in the additional affidavit filed by the petitioner on 11th of May 2026, a medical opinion had been enclosed as Annexure B, wherein the senior consultant of Sri Sankardeva Netraloy had advised that repeat right eye corneal grafting can be done to attempt vision improvement. It was also mentioned in the said medical opinion that possibility of graft failure was also explained to the patient, which the patient seems to have understood. Ms. Grover, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner have been taking treatment under one Dr. Fogler,
Please, my lords.
who Madam,
My
which
lords,
is which is the
yes. At the Apollo Cornea Clinic, para 7 of my
this is the Apollo Health City.
Apollo Cornea Clinic in Hyderabad.
Apollo
Para 7.
Cornea Clinic, Hyderabad. And till date, the treatment meted out to her have been relatively successful. The learned counsel further submitted that in view of the explanation that upon explaining the possibility of the graft failure by the senior consultant of the Sri Sankardev Netraloy, the petitioner would like to avail her further treatment of right eye corneal grafting at the Apollo Cornea Treatment, which is a specialized medical institution. The learned counsel, the learned senior government advocate, submitted that the respondent authorities, both in the Home and the Family Welfare Department, are presently considering the said aspect, so that an update be provided by the respondents on the next date as to whether the respondents in the state, whether in the institutions, in the eye clinics and institutions available in the state of Assam, whether the right eye corneal grafting can be successfully done, or would it be better for the petitioner to avail such treatment at the Apollo Cornea Cornea Clinic at Hyderabad, where she have been receiving regular treatment?
My lords, if I may just, very sorry to interrupt. Insofar as regular treatment is concerned, she does go to Shankardev Nethralaya. I have in fact annexed those.
Where she had the procedure.
Only the surgery. Surgery she goes to Hyderabad.
Procedures.
Please, my lords. Please, my lords.
Where she had her earlier surgical procedures carried out.
Well, I have got my instruction from Home Department. Home has taken up the matter with the health and family welfare. From health, I have no instruction.
It's okay. The petitioner shall also provide necessary inputs on this aspect. Madam, I am using this necessary inputs. I don't want to specify much in this. It may impact.
I'm deeply grateful. I'm deeply grateful.
Taking into account that the petitioner admittedly has suffered from an acid attack and for the last, this happened in 2019.
16, March 2016.
Last decade, and since the last decade, the respondents 1 and 4, along with the Health and Family Welfare Department, shall take necessary inputs and place it before this court on the next date without fail.
My lords, can I seek one more indulgence in this, since the learned government counsel is taking instructions? In para 5 of my affidavit, I have also enclosed the bills which I have incurred from treatment that I need to take regularly from the Shankar Dev Netralaya. They come to a total of about 1,21,500. If there is some nodal officer who's appointed, I can submit the bills. These, because this treatment is ongoing. My annexure A, I have enclosed all of them.
1,21,500.
Please, my lords.
The respondent shall also apprise this court on the next date as to what steps have been taken Madam, there is no bill.
And also there is at annexure A, she has shown about her treatment, because at each occasion and the prescriptions.
Understood, but there is no bill.
My lord, some of them have bills. If my lord would see page 50, it says charges on the right side column at page 50, charges 400. There is,
Understood, but
my
anyway,
lord, that is why I said we'll need a nodal officer in the department to whom all this can be submitted and they can verify the same.
but you yourself say at this paragraph number 5 that you don't have the bills.
No, my lords, that is some bills are not there. Some are. For
As
instance,
the
again,
victim has not been able to preserve all bills and payment slip, this amount may be reimbursed as a fair approximation of the cost incurred.
yes, all bills are not there. The bills that are available, because the matter was not getting listed from 2019 onwards. This is treatment from 2020 onwards. Whatever bills are available, we have placed them before the on this in this additional affidavit. All are not available. She has not preserved all, but quite a few are.
Okay. So এনেকে লেখক হা এইটো আগৰ খিনি কাটি এখন কাটি দি এনেকে Ms. Grover, the learned counsel have also drawn the attention of this court that the petitioners since 2020 have been availing and getting treatment at the Sri Shankardev Netralaya and incurring approximately 1,500 rupees per month. And the said amount as on the date of filing of the additional affidavit comes to rupees 1,21,500. It is the opinion of this court that the bills in respect to that amounts bills of the medical expenses be submitted. Mr. Dinath, the learned counsel, senior government advocate, shall obtain instruction as to before whom the petitioner is required to submit such medical bills so that reimbursement can be obtained. First of all, such instruction list this matter on 7th of September 2026.
Please, my lords. Please, my lords, grateful.
Mr. Nath, I will use one letter out there, line out there that amount which is being mentioned, providing that information would not mean that you accept. So it is made clear that providing such name of the nodal officer would not deem that the respondents have accepted to payment of the said amount, madam. Because otherwise their stand would be otherwise would go with it.
So I'm led by senior counsel Debarment Saikia. He's on another court. He's coming. Let her start. I'm just informing that.
What is the matter about
Blacklisting issue also.
blacklisting of whom?
Of the petitioner.
Why?
Lordship, on the basis that there is an FIR and an offense under PC Act. Lordship, may I straight away take you to the banning order? They call it the banning order at page 243. Just before that, Lordship, the petitioners.
Yes, what is this?
Lordship. Yes, isn't it?
We'll consider on another date.
Lordship, there's an urgency.
What urgency?
Lordship, 1 year of banning is already done.
Let it be 1 year then. I keep you. I mean, so whatever you have submitted, I'll maintain it. Let us have it on 10th of January, 10th of October 2026. 1 year?
No, Lordship, already to this month is 1 year. So if you want to give me 1 more year, it should be this month.
No, the order is of 10-10.
No, Lordship, but it's with effect from show cause notice, which is 29 July. So this month is the month for 1 year.
We are concerned only, have you challenged the show cause notice?
Earlier. And
Have
we
you
will
challenged the show cause notice?
not in this petition.
So then obviously.
Blacklisting is
So
10-10.
10-10, I give you 1 year. You said 1 year.
No, Lordship, 1 year is gone. From July to
No,
July,
we are
1 year.
concerned with 10-10.
No, Lordship.
Mhm.
It's with effect from, Lordship, may kindly take a look.
Yes, effect from
It's with effect from 29/7/2025,
what? Therefore,
which in my humble submission also is unfortunate.
Division of bind and so, so forth.
And I don't usually raise this objection ever, but I will say it this time. The matter came up on 13th. It was accommodated because the Advocate General was not there. The matter came up on 16th when the Advocate General was not well, so I could not object.
Earlier it was suspension.
Suspension.
Yes, sir. This petition is against banning, and the banning is with effect from 29 July 2025. If your lordship is adjourning it because you want to, they're seeking accommodation. Yeah, because it's the 4th time you're accommodating.
Okay, we take it as the last item of the day, 5 o'clock.
Oblige your lordship. Yeah.
May I please, Your Lordship? My lord, this case relates to cancellation of the, my lord, allotment of the retail outlet by the, my lord, respondent my lord, Petroleum by applying, my lord, erroneous norms, my lord. To your lordship's direction, my lord, I have brought on record the notice, my lord, for appointment of regular and rural retail outlet by way of an additional affidavit, my lord, whereby the present petrol, my lord, palm in question at page 79, my lord, has been indicated to be regular, my lord.
What is that?
Page 74, my lord, is the notice for appointment of regular and rural retail outlet, my lord.
RO, regular or rural? Regular.
Regular, my lord. Page 79, serial number, my lord, 112. Pathargandhi bypass, starts, my lord, point Karimganj side to Sudeshna Memorial
Regular.
Park. This is the, my lord, petrol pump in question. So it is, my lord, indicated as regular. Now, if your lordship comes to the impugn order at page, my lord, 61, my lord, annexer 60, annexer 15, my lord, page 61. This is issued by the Bharat Petroleum Corporation addressed to the petitioner by the head of the territory. Serial number 2, my lord, they have assigned the reason. This is to inform you that the Land Evaluation Committee visited the site offered by you on 3 August 25 and found the same to be not meeting the required norms as mentioned below. Offered
What do you
land,
mean by regular?
regular is not rural, my lord.
Where do we get it? There must be somewhere.
It was categorized on the basis of the combined sale volume, my lord. The expected sale volume, my lord. It was categorized, my lord. But here, the combined sale volume is shown as 160 my lord, per kiloliter per month, my lord. So it comes under the regular, my lord.
What is regular and rural? Somewhere it will be there, no?
Yes, ma'am.
Why haven't you enclosed the guidelines? Or should we have it one copy with us so that councils like Mr. S.K. Talukdar will come up out here and argue, and we should have, like we have for ACB, we have APDCL, we have it. So something like this, we keep it for guidelines. Then otherwise, what is the point? I think the definition of regular, rural will be there. Yes, what is this? Where do I get the definition?
Page 1, my lord. Page 3, my lord, in bottom, my lord. Identification of the location, my lord.
Yes.
Can you see, my lord? Clause 1A, my lord. Surplus 2, my lord. Expected sale volume 150 kiloliter per month. So here, my lord, the page 75, my lord, the expected monthly sale volume is 160 million.
This is ABCT, National Highway, Class 2 town, and rural RO.
Yes, ma'am. In rural, ma'am, the volume is 25 KL mile
Per month.
Yes, ma'am.
So here identification type of AI is, but there is no regular.
Yes, ma'am.
Where is regular? There is no definition of regular.
Yeah.
You have definition of remote, low service, rural, feasibility, very regular. What is this? What is this book again?
That was not the next part.
There is another one.
That was not the next part. This, which was.
You are,
But this is
why you are showing me 2018 now?
But this is my internal.
No, this is 2018.
Yes.
We are concerned with, when was the notification issued? The advertisement?
My lord, this is of 28/6/23, my lord. 28/6/23.
So this June 2028.
Yes.
June
Our regular retail outlet, my lord, location on
regular,
highway.
Location on highways,
national highway.
state highways, urban, semi-urban, so and rural. Got it. Then
The rural, my lord, rural location in rural area, but not on a highway. So it's outside the municipal limit of a city or town.
understood. Now, why have you rejected it?
Because by the land located in the rural estate states of the NSML.
Where's the annexure 15?
My lord, page 61. Serial number 2
Inform
is
you
the-
that the land evaluator visited the site offered by you on 3rd and found the same to be not meeting the required norms as mentioned below. Offered land not meeting NH norms as there is an intersection with the road at 150 meters. How does this have anything to do with rural or regular?
my lord, page 68, my lord, if I have not mistaken, it starts from page 67, annexure 18. These are the norms laid down, my lord, regarding intersection, my lord, by the Ministry
Location
of Road and
on-
Transport.
On rural stretches of national. highway.
Yes. Now, serial 2.2, my lord, in respect of rural stretches, the distance, my lord, from the intersection should be not within, my lord, 300 meter. If it is within 300 meter, it is restricted, my lord. And if your lordship comes to, my lord, the next page, this is in respect of urban, the restricted area is 100 meters.
No, 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 no. You see, this is done by the national highways,
Yes, right.
understanding of rural. This is done by the guidelines of IUCN. These are two different things. Now, national highways will be in the rural areas. There might be in the rural areas, national highway has said that if there is a national highway running in the rural area, then in that regard, distance of any intersection with any category of road and medium gap is 300 meters. Any barrier including toll plaza and railway level crossing 1000 meters. This is as per national highway. But for them here, the rural is different. The rural means location in rural areas but not on highways. Is your land in highways?
No,
Where?
urban. Urban area, municipal area, my lord.
So there is no national highway.
My lord,
It is located on NS 08 mile, NS 8 mile.
How can it be in the municipal area?
It's not a
Highway,
municipal area, my lord.
but not on highway.
As on the date of my lord,
NH
land
so and
evaluation-
so and outside the
State, madam.
municipal limits of city or town. This is rural. And so, location on national highways, state highways, etc. and urban, semi-urban within municipal so and so. Is your land abutting the national highway? Simple question.
yes, my lord.
If it
At-
is so, then it has to abide by the terms of the national highway.
Yes, my lord, page 58, your lordship will come. Come to page 58, my lord. This is the letter by the NHIDCL, National Highway Infrastructure Development Corporation.
They intimate that the existing two-lane road at the mentioned location is being upgraded into 4. The mention is not falling under the proposed right-of-way as per the land acquisition, hence the plot shall not be affected by IA. That has no relevance. My question is your land abutting the national highway? Answer to that, you have to give.
this is a LEC. my lord. The expected my lord, sale volume, my lord. For rail area, my lord, the expected sale volume would be my 25 KL, my lord.
Where
Clearly-
do you get it?
Yes, my lord. Kindly see me the page 75, my lord.
What is this?
But this is a land evaluation committee report, my lord. Where it will be shown, my lord, it is within my lord, 150. It's not within 300 meter, my lord, in last page, my lord.
My lord, let them file an affidavit. No affidavit is filed, my lord. And we need to respond to it, my lord. He's, my lord, since placing the documents like that, my lord.
Obviously, they should. But the intersection is on the other side of the road. Or does it have any relevance?
It is my start from my lord.
Understood, but you have to apply your mind on that. When you see this intersection,
It is from my lord, Pathargandhi bypass, from bypass start point.
understood, but the question is, you are saying about this location norms in rural stretches of national highway. Have you made the National Highway a party?
My lord.
Huh?
Party, my lord.
Who is appearing for that?
I responded number 3, my lord.
Nobody is appearing. Why National Highway is not made a party? Mr. Council.
NHI DCL.
But this one also, my lord,
Mr. Council. National Highway. You see, the action is taken on the, have you made the Ministry of Mort? Mort a party? No.
My lord, I'll add to it, my lord.
They are the main persons who can explain it, whether this will apply in the rural sec or whether the national highway, if it butts the land which is in the town area, whether this will apply.
Yes, that is the.
Once they give the year, you get a thing and we can interfere with that,
Yes, sir.
isn't it?
Yes, I'll correct it, my lord.
And you have not filed affidavit. There's a stay.
No stay, my lord.
Okay, we stay it. Heard.
from the LEC, it is seen there, from the end also, my lord, it is 150 meter only, my lord.
What?
From this side also, it is only 150 meter. It should be 300 meter.
Understood, but whether it will apply?
Yes, my lord.
Why?
But it's a regular, my lord. Retail outlet, my lord.
Understood, but would it apply if it doesn't, it is not if it is in the town?
No, but that's why, my lord, I am shown the expected sale volume, my lord, 75, my lord. Can you see?
No, that you are referring to a 2018. See, 2023.
But I know, my lord, the Royal, my 25 KL is the maximum.
Where is it mentioned here? In the 2023 term.
I have shown it.
2018, we don't go by that.
Yes,
Don't radio. But
even if, my lord, from
they make all these submissions.
from 75 also, my lord, can you see, my lord, for
Not
regular
on
to
that.
160.
My question is here, you have a rural and retail outlet. When in 2023, you have a particular definition of rural and regular. Why should we look into other guidelines?
But it is not a rural area, my lord. It says a NS highway, my lord, besides the national highway, my lord.
Understood. But if the highway is within the municipal limits, then what do you say about those out there in the in the bypass?
Yes, ma'am.
Gauhati. You have those all these retail outlets.
Yes, ma'am.
They come under the municipal limits.
But they have to obtain the permission, but yes.
They have the municipal limits.
Yes.
They also come within the intersection.
Yes, maybe.
They are abutting the national highway.
But there is an acceleration lane, my lord. They have made a lane, my lord.
Here also you have a lane. Kindly see.
Yes, ma'am.
So from there is a right of way of around
Yes, ma'am.
22.5 meters.
7 meter, my lord.
So that is the, but I'm not on that. My question is, the best option is to get clarification from the national highway in that regard. But you have not made a Ministry of Mort. I hope.
So far, the representative is concerned, it was not dictated in our file, my lord. Yes.
Mr. Talukdar has more faith in the court.
Since we are going to my steady operation, my lord.
Mr. S.K. Talukdar, the learning counsel appearing on behalf of the petitioner. And Mr. S. Botagu, the learning counsel appearing on behalf of the respondents. Numbers?
1 and 2, my lord.
1 and 2. The present petition has been filed by the petitioner saying the communication dated 24 4/2026, whereby the petitioner's provisional selection was rejected or was cancelled on the ground that the offered land was not meeting the NH norms, as there is an intersection with the road at 150 meters. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner, drew the attention of this court to the norms for grant of permission for construction of access to fuel stations, wayside amenities, connecting roads, etc., issued by the Ministry of Road Transport and Highways, and further referred to clause 2.2, wherein it is mentioned that the location norms on rural stretches of the national highway. The learned counsel further referring to the advertisements which have been brought on record by way of an additional affidavit, submitted that the type of dealership is rural retail outlet,
No, regular, my lord.
a regular retail outlet.
My lord.
And in terms, and as it is a regular retail outlet and not rural, comma, the guidelines at clause 2.2 issued by the Ministry of Road Transport and Highways dated 26/6/2020 would not apply. This court duly takes note of that the petitioner have impleaded the National Highways and Infrastructure Development Corporation Limited. And in the opinion of this court, the said party would have no relevance in respect to the instant proceedings. The petitioner ought, for the purpose of proper adjudication of the present dispute, the Ministry of Road Transport and Highways, Government of India ought to have been impleaded as a party, is required to be, ought to have been made a part, ought to have been arrayed as a party to the instant proceedings. Taking into account the issue involved, this court impledes the Union of India represented by the Commissioner and by the Secretary to the Government of Assam, Government of India, Ministry of Road Transport and Highways, Transport Bhavan, 1 Parliament Street, New Delhi, 110001, as the respondent number 5 to the instant writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order as well as the memo of parties, make necessary correction of the cause title and update the same in the CIS. The memo of parties be filed within 2 days. Issue notice upon the newly impleaded respondent number 5. Mr. S.S. Roy, the learned CGC, accepts notice on behalf of the newly impleaded respondent number 5. Extra copy of the writ petition be served upon him during the course of the day. The respondent number 5 shall apprise this court as to whether by way of an affidavit as to whether the guidelines dated 26/6/2020 and more particularly clause 2.2 would apply to stretches of the national highway which falls within the urban
Urban municipal area, my lord.
urban municipal no, urban bodies.
Urban body.
Whose the affidavit to that effect be filed on or before 23rd of September 2026. Next, this court also takes note of that the learned counsel takes note of that during the course of the hearing, Mr. S. Botaku, the learned counsel, have placed certain documents. In the opinion of this court, on the basis of by placing such documents, the stand of the respondents cannot be discerned. Under such circumstances, an opportunity is granted to the respondents number 1 and 2 to bring on record their stand by filing the affidavits on or before 23rd of September 2026. Failing which, this court shall proceed with the instant proceeding by applying the doctrine of non-traverse. This court have also taken note of the respective submissions and from a perusal of the guidelines dated 26/6/2020, read with the advertisement. It is the opinion of this court that the petitioner have been able to make out a case for grant of certain interim directions. Accordingly, till the next date, the respondent number 1 and 2 shall not take any further steps in respect to the RO dealership at Patharkandi bypass, bracket from bypass start point, bracket close, Karimganj side, bracket close, bracket open, Karimganj side, bracket close, to Sudeshna Memorial Park on NH08. Pursuant to the communication dated 24/4/2026.
Deeply.
County Commissioner has filed an affidavit, madam, but it is neither here, neither here, madam. Because whether, madam, the location is
Who?
the Deputy Commissioner, madam.
Mr. Botakur, you cannot quarrel with the Deputy Commissioner's
no.
affidavit unless and until you file your affidavit. It is something like people in glass houses throwing stones. You are the best example for that. This is the matter on 28th of September. But Mr. Talukdar, you should improve your pleadings by putting properly that party. Why you are making NHI DCL a party?
I'm sorry, I take the responsibility. I'm sorry.
Yes, Mr. Sharma, what is your case?
Lordship, here a part of the land of the petitioner has been acquired by the National Highway. And
Who has acquired?
National Highway Authority.
The National Highway?
No, Lordship, private respondent.
Huh?
Private respondent.
Then
Lordship,
then what happened?
Then, Lordship, it has come to notice of the petitioner that the land which belongs to him, the private respondent has fraudulently inserted their name in the Jamamandi land records. Lordship. Now, in spite of the petitioner submitting before the appropriate authority that he is the owner and the possessor, he has been excluded from the compensation amount. Now, Lordship, it has been
Your name has been removed.
removed, Lordship.
Then
Removed, Lordship, on the submission that I have expired, Lordship.
you have expired.
Yes, Lordship.
Then
This, Lordship, I will bring it to the notice, Lordship.
we are taking the
Page
case of a dead
37,
person.
Lordship, page 37, 3, Lordship.
Who has expired?
Lordship, in my lifetime, Lordship.
Who has expired? There are 2%,
Yes,
both
Lord.
expired.
No, Bhuvan Chandra Gosai, they said he expired during the lifetime. There is a settlement between the private parties and me that I have transferred the land to them.
You have transferred.
Yes, Lord. But in reality, I have not transferred. It has been brought to the notice of the competent authority.
Then why you are not before the year? Why the reference has not been made?
Reference has been made, Lord,
Who?
to the civil court.
Then
Then, Lordship, it has been, there is an opinion taken by the reference court that is page 53, Lordship.
page?
53, the opinion part, Lordship.
What?
It is clear that the learned additional deputy commissioner and the government pleader labored under the wrong impression that the dispute has to be referred to this court. While it has already been observed and held that the learned as well as the government pleader that commissioner is not in possession of the aforesaid land. It was already opinion that Ranjit Tamang and Bishanath Dihingya, Bishanath deserves the compensation as.
You have challenged this order?
Yes, Lord. This
You
order
challenge
has-
this order?
Yes, Lord.
We set aside this order and direct them to read it again, take into account.
Lordship, it may also be, Lordship, it may also be.
The competent authority has the jurisdiction to determine they are who in its opinion are entitled to receive the and remand. Hence, in this case, is remanded back to here. Hello. You are challenging this order?
Yes, Lordship.
Sure.
Yes,
Where is your prayer?
Lordship, I have.
Where is the prayer? Mr. Counsel, where is your prayer? How can one help you? That is why I asked you, have you challenged this order?
Lordship, I am praying for a re-enquiry, Lordship. Re-enquiry?
Mr. Counsel, this order needs to be challenged and therefore challenged, and this order thereupon has to be set aside. After setting aside, I can pass a direction for this authority, the district judge Dibrugarh, to decide. There are many judgments of mine in that regard.
Yes, Lord.
So therefore, without a challenge to this order, how can I, this is a judicial order. How can I help you?
I will amend the prayer, Lordship. Already prayer portion, Lordship. I will amend the prayer.
You gotta stay,
Yes, Lord.
stay.
Yes, Lord.
Is a stay given?
Yes, Lord. Not to release the compensation.
Do that.
Your Lordship, the private respondent number 9 and 15 expert Lordship. They make substitute. Respondent number 9 and 15.
Who is respondent number 9?
Respondent number 9 is Lordship.
Well, what's the name of respondent number 9?
Ramji Gosai.
Huh?
Ramji Gosai, page 5 Lordship. Ramji Gosai, respondent number 9, and respondent number 5, Kadar Gosai.
Huh?
This Kader Gosai is also respondent number 15. He also expert Lordship. 2 private respondents. Respondent number
They were your persons?
Lordship, private respondent.
The names of the legal representatives on the next step.
Lordship.
The present petition has been filed by the petitioner. Seeking a proper inquiry verification regarding the actual pattadar of the land at measuring 0.020 hectares covered by dag number 192 of patta number 37 situated at Gospuria, Bongali Gaon under Kuang Moza, Dibrugarh, and further seeking compensation against the said land. It is seen that in pursuance to the claim made by the petitioner, a reference was made under section 3H4 to the National Highways, under the National Highways Act 1956 to the court of the district judge, Dibrugarh. The said reference proceedings was registered and numbered as LA case number 4/17. By the judgment dated 13/9/2019, the learned district judge, Dibrugarh, came to an opinion that such disputes can be decided by the competent authority in terms with section 3H3 of the National Highways Act 1956. In the opinion of this court, the said judgment of the learned district judge Dibrugarh is palpably erroneous in view of the settled principle of law that whenever there is a dispute as regards the apportionment of the compensation or the entitlement of the compensation, it is only the principal judge of the civil court, that is the district judge, of the civil court within whose jurisdiction the land is acquired, has the jurisdiction to decide the question of entitlement as well as the apportionment of the compensation. However, upon perusal of the prayers, the reliefs which have been sought for, it is seen that there is no relief sought for as regards the challenge to the award dated, to the order dated, to the judgment dated 13/9/2019 passed in LA case number 4/17. The learned counsel appearing on behalf of the petitioner submits that he will file an amendment application to do so. Liberty is granted to the petitioner to file an amendment application. It's advised. Mr. S. Sarkar, the learned counsel who represents the respondent numbers
15. 8 to 15.
8 to 15, submits that in the meantime, the respondent number 9 and respondent number 15 had expired. In the meantime, the respondent number 9, respondent number 8 and respondent number 14 had expired. 15. Who expired?
9 and 15, Lordship.
Ramji Gusai.
Ramji Gusai.
The respondent number 9 and respondent number 15 had expired. The learned counsel appearing on behalf of the respondents, private respondents shall provide the names of the legal representatives of the respondent number 9 and respondent number 15 so that the petitioner is in a position to take appropriate steps. First, when
3 weeks or 2 weeks, Lord.
file you provide on the list this matter upon filing of the interlocutory application seeking amendment by the petitioner. Interim order passed earlier shall continue. Interim order is there, na?
Yes, Lord.
Please, until further orders.
Until further orders.
Okay.
Okay.
But you file it, Mr. Counsel. I've gone out of the way to help you out by asking you to do it. Otherwise, this is a case for dismissal right away. The facts are good, but the manner in which you have filed proceeding is wrong. Yes. Yes.
My lord, this is regarding my lord, the partition and my lord, demarcation of a particular plot of land of the petitioner that has been pending before the my lord, circle officer.
What
Since, my
happened?
lord,
In the meantime, demarcation done.
not yet done, my lord.
Oh, I have received the instruction way back on 21, my lord. Affidavits has not been filed in this regard.
What?
Instruction has been received way back in 21, my lord.
What does he say?
My lord, the demarcation could not take the place because the co-potter's land without the consent of the all co-potters, my lord.
Why?
My instruction says, my lord.
Is the demarcation required to take the permission from the others?
Co-potter is necessary, my lord, to give notice.
Show me. Today, he is one of the co-potters. He wants his land to be shown.
That, my lord, in the.
He can very well ask that my son, the other people may very well say that he will say possession should not be disturbed.
3 bigger, 3 quarter in the total dug, my lord. And his share is 1 bigger. One bigger. So, my lord, other co-potters, obviously, my lord, it's needed, my lord.
So therefore, have you gone for partition?
Partition as well as demarcation,
Partition done or not?
not yet done.
But then, without a partition, how can there be a demarcation?
Now, since my lord, partition, application for partition as well as my lord, demarcation. is
No, no, a partition application has to be filed under 98.
Yes.
Have you filed that?
My lord, plain
Where is the
application,
partition application? Show me.
plain application has been filed.
Huh?
sir.
No, this type of application, without a partition, there cannot be a demarcation. Then it has to be taken out, na, from 3 bighas. How much is your land?
Yes, yes.
Where's the partition?
Yes, and that, my lord, we will file, my lord, appropriate petition before the, my lord, competent authority. That let it be disposed of by, my lord,
Where it
that
is,
of
my
the
lord. Annexure 6 shows that, my lord, prayer for demarcation.
demarcation.
Then
Demarcation. Partition is something totally different.
different. Go. Well,
Separate part.
We will file appropriate petition, my lord, before the competent
In the
authority.
case of 20, man, 2020.
Taking partition.
Present case of 2000.
there's no limitation.
Not in that, man. Present status also, man.
We close it.
Well.
Giving you liberty to approach the. The petitioner heard Mr. So-and-so, the learning counsel for the petitioner, so-and-so appears for the so-and-so. The case of the petitioner herein is aggrieved by the inaction on the part of the circle officer, Botiamari Revenue Circle in the district of Bongaigaon for not carrying out the demarcation of the land at measuring 1 bigha covered by patta number 125 of tag number 179 at village Korea, part 1 under Boitamari Revenue Circle in the district of Bongaigaon. It is the case of the petitioner herein that the petitioner is the absolute owner of 1 bigha of land at measuring 1 bigha covered by dag number. Where's the dag number?
Dag number 179.
Dag number 179 of periodic patta number 125 issued, which have been issued in favor of the petitioner and 2 other persons. The petitioner thereupon had filed an application seeking demarcation of the land at measuring 1 bigha, which is covered by dag number 179 part of patta number 125. And the said application as well as the subsequent representation having not been considered, the petitioner has approached this court by filing the present writ petition. This court inquired with the learned counsel appearing on behalf of the petitioner as to what demarcation is being sought for. What is the demarcation you are asking?
the particular 1 bigha of land, my lord,
You want to demarcate from where?
out of the, my lord, total land.
Or from?
My lord, since there is
Is
a
it your only thing?
3 bighas of land in the particular, my lord,
Where have you mentioned in your writ petition? 3 bighas of land.
is, my lord.
Huh?
It is not specifically, my lord.
This is not how you draft a petition. Yes.
Land
You
holding
mentioned a
certificate.
single word
Yes.
that it is 3 bighas.
Page 14, my lord.
It's 14. No,
Yes.
no. I'm asking in the writ petition, is it mentioned anywhere that it is 3 bighas, of which partition me 1 bigha?
That is specifically not narrated, my lord.
Not a
Page 14,
single
lordship.
word mentioned. See,
Page 14, lordship will find.
the case of the petitioner herein is that the petitioner is the absolute owner of the land measuring 1 bigha covered by. Mr. Mondal, I'm imposing a cost of 25,000 upon you for drafting these horrendous type of petitions. You don't even mention paragraph. Look at paragraph 2.
Yes,
Covered
madam.
by dag number 179, part of patta number 125 at Korea. Covered by village what? Village is also not mentioned.
Village, my lord, one. Village, my lord, Korea, pardon.
Village covered by patta number so and so of village Korea part 1 within the Boitamari revenue circle of Boitamari village in the district of Bongaigaon, Assam. It is the case of the petitioner that the said 1 bigha of land is a part of 3 bighas, 3 katha, 7 lecha. 3 bighas, 3 katha,
7 less, sir.
7 lechas, which is contained in the total dag number 179 of patta number
125. 125.
125. On account, the petitioner have sought for demarcation of the 1 bigha of land before the circle officer Boitamari Revenue Circle by the application filed on 22/1/2020. On account of such an application, on account of inaction on the part of the respondent, number 5, the present writ petition was filed by the petitioner, taking appropriate writ direction and order. This court, by an order dated 22/1/2021, issued notice. Mr. Endas, the learned counsel, appearing on behalf of the respondents, numbers
1, 3, 4, and 5.
1, 3, 4, and 5, had submitted. The petitioner have sought for demarcation without seeking any partition amongst the other co-patadars. In addition to that, the petitioner have also not taken the permission of the other co-patadars or even made them parties to the instant proceedings. In the instant case, it is seen. From the Annexure 1, which is the periodic Khiraj Patta. That the petitioner's name is included in dark number 125 or 179 or Patta number 125. The said Patta contains 3 bighas, 3 katha, 7 lechas, out of which the petitioner claims that he is the owner of 1 katha of 1 bigha of land.
The patta, my lord. Annexure 1.
Yes, what is that?
It says son of Hesabuddin. But in the cost title, it's shown as Harabuddin.
Kindly see page 12. What is this page 12? Where you need, how do you get 1 bigha? Mr. Mondal, how do you get 1 bigha?
Page
for the
12, my
petitioner?
lord.
Where is it mentioned? What is page 12?
Annexure.
Page 12 is the Zobabundi Kobi.
Where is it in page 13? 1 bigha? Is the petitioner's land? Not there. From the above materials on record,
Name is there, my lord, page 13, serial number 2, Abdul Wahab.
it is seen that there is no partition amongst the various patadas,
Serial number 2. Abdul Wahab.
which would show that the petitioner is the owner of 1 bigha of land. Therefore, from these documents, it cannot be discerned that the petitioner is the owner of 1 bigha of land. Consequently, this court therefore cannot direct a demarcation to be carried out by the respondent number 5 without the petitioner seeking for partition. Accordingly, this court does not find any merit in the writ petition for which the writ petition stands dismissed. Be that as it may, before parting with the record, this court, however, observes that the dismissal of the writ petition shall not preclude or prejudice the petitioner to file appropriate applications seeking partition of the land, and thereupon, after the partition is carried out by the revenue authorities, to seek demarcation.
Obliged.
Cost. No, this is not, you have to improve. I think this, your writ petition should be put in this TV as one of the examples of drafting writ petitions in such faulty manner. I
I'm
cannot
taking
be.
the responsibility. One of my colleague has drafted this.
Why it is?
I'm taking.
You
this
don't even
responsibility.
mention,
Yes.
and can you see page 12?
Yes, I have seen, my lord. I have seen. Nothing is mentioned.
What you have typed out is completely different from page 13,
Page 13.
isn't it?
Yes.
And you
Mistake.
have certified it, whoever has certified it. Same is page 14 also.
Yes.
The instructions.
Yes, supposed to take instruction.
My lord, the trees, my lord, respondent, my lord, because order was passed by the respondent number 3. Order was, my lord, passed by the respondent number 3 member secretary, state level advisory committee. But steps was taken, and I have seen, my lord, on AD card, my lord. respondent number 3.
Yes.
Number 3 has issued the order. We don't represent respondent number 3. But the steps was taken, the ID card has returned.
The member secretary of the state level advisory committee is a committee constituted by the director of sports.
My lord.
Therefore, I asked Mr. S.S. Roy to obtain information.
My lord, he wrote letter, my lord, letter from this letter from. He wrote letter, my lord, but to the, not to 3, my lord, he wrote to 1 and 2, my lord.
Obviously to 2. Then what happened?
My lord, he hasn't received any instruction from 1 and 2, my lord. This is the letter, my lord. Yes. Not one instruction. Oh, thank you. I'll do that. No.
Get your instructions from this because you see, no,
I'll take my.
no. The reason is we have a particular affidavit, the instructions provided by the member secretary on 6th of March 2026, wherein it is stated that a petitioner is entitled for which it has been sent. Out of that, petitioner have received around 80 lakhs.
Yes.
And further another 400 lakhs, which is around 4 crores.
My lord.
Demand has been made, but the government, that is you for whom you are representing,
My lord.
they are holding to it.
My lord, I'll take instruction. I'll take.
So even if after this they have not provided the instruction, we call these persons concerned, the commissioner and secretary halt.
My lord,
Director.
this time, my lord, I'll take up with the, my lord, respondent number 1, my lord.
The petitioner herein has filed the instant application. The present writ petition being aggrieved by the non-payment of the amount of the contractual dues against the supply order dated 23/2/2016, issued by the respondent number 3. It is seen that the respondent number 3 have sent a communication to the Deputy Registrar, Gauhati High Court on 6th of March 2026, wherein it is categorically mentioned that the respondent number 3 duly admits that as per the supply order dated 23/2/2016, the petitioner supplied the sports goods obligates to all concerned MLAs of 126 assembly constituencies for distribution to all sports association and clubs of Assam, and submitted bills, vouchers, etc. to the respondent number 3 for an amount of rupees 3 crores 94 lakhs 9,400 for payment. It is also seen from the very parawise comments so submitted that an amount of rupees 80 lakhs have been paid to the petitioner sometime in the year 2017. Subsequent thereto, another demand was submitted by the respondent number 3 to the tune of rupees 3 crores 16 lakhs 50,000.
14 lakhs.
But while submitting this demand, the respondent number 1 had by the communication dated 19/5/2017 informed the respondent number 3 that an inquiry would be conducted on the utilization of the granting aid fund of rupees 400 lakhs, and for the said reason the amount is pending for payment. It therefore appears from the above that the respondent number 3 duly admits that the petitioner had supplied the sports kits, sports goods obligates to the tune of rupees 3 crores 94 lakhs 9,400. However, it is on account of the respondent number 1 and 2, the amounts have not been released. It is also seen that the inquiry which was to be conducted was sometime in the year 2017, and almost a decade had passed, which is almost a decade. Further to that, even the respondent number 1 and 2 have not filed their affidavits in the present proceedings. On 17/7/2026, when the matter was taken up, this court asked the government counsel to obtain necessary instructions. However, in spite of the government counsel writing a letter to the respondent number 1 and 2 on 17/7/2026, the respondent number 1 and 2 have not responded. From the above, it therefore transpires that on account of the actions of the respondent number 1 and 2, this court is not in a position to progress with the present proceedings. Ms. Yuda, the learned additional senior government advocate, submits that an affidavit on behalf of the respondent number 1 and 2 would be filed within a week's time. List this matter on 9th of September 2026. The respondent number 1 and 2 shall bring on record their stand by filing the affidavit on or before 2nd of September 2026. Failing which, this court shall be constrained to seek the personal appearance of the respondent number 1 and 2, the incumbents who are holding the post of the respondent number 1 and 2. Yes, Mr. Mahmood.
My lord. The present petitioners, husband and father, purchased 1 bigha 3 katha 19 lesas of land through two different registered sale deeds. That was in the year 1970 and on 27/12/1976. After purchasing the said plots of land, he also occupied the land, and in one part of the land, he constructed his dwelling house, and another part of land he used for cultivation purpose. And here, the persons who sold this plot of land are the father of private respondent number.
Where is your notice?
The notice is page 29. Renubala Das, kindly see page 8. Renubala Das, she is respondent number 8, and 9 is Paswanti Das. Now, this plot of land was purchased from their father, Banaram Das, and Baswanti Das' father is Ratan Das. So, their father sold this plot of land to late Mohiruddin Sheikh. And that was in the year 1970 and 76 respectively, by registered sale deeds. Now, on Lordship kindly listen of page 29, here on 19/4/22, the circle officer, Dotma Revenue Circle, issued a notice to the present petitioner number 1, who is the wife of late Mohiruddin Sheikh, that the undersigned will evict the encroachers of Dag number 164 and Dag number 131 of village Bagunwari in favor of MNP TV holders, MNP TV number 5 and MNP TV number 11 on 27/4/22. Now my submission is this plot of land was purchased by our husband and father in the year 1970 and 76. It is a Mehdi plot of land. And this tribal block and belt, that lordship, I have a memorandum of settlement of Bodoland Territorial Council. In clause 4, it is said that the persons who are residing there before creation of this BTC, they shall have usual rights just like the tribal people. Now, when we have purchased the land in 1970 and 76, how our plot of land can be brought under MNT? That too has been sought to be given to two ladies whose father sold this plot of land to us by registered sale deed. Now they have submitted, Lordship kindly see, I am showing your Lordship one after another. The registered sale deed, first page 19.
Nobody can read head and tail. Why haven't you translated the entire document? Why only relevant?
Actually, my lord, we filed a petition for some, because it's a old deed, and Mohiruddin Sheikh went to.
No, your sale deed. Why haven't you translated the entire document?
It is not so feasible, madam. But I have given the sale deed number. And we saw the certificate.
No, that cannot happen like that.
Lordship, let me submit. That means we wanted to have the certificate copy of the sale deeds, but the authorities are not giving that by showing this and that cause.
So this is the original
This
copy.
is Xerox copy. Original copy was given to a lawyer at Kokrajhar, and by our husband and father, Mohiruddin Sheikh. Just after coming from the lawyer at home, he died. So details of the lands documents, original documents we do not have at present. But we have given the cell deed number. So on the basis of cell deed number,
No, you have given page 19, 20, 21, 22, all these sale deeds.
yes, cell deeds.
Then,
But not, these are not so much clear matter.
so then,
It is registered cell deed, but authority, it is with them. They may provide that, and for that we have filed RTI applications, but they are giving answer, vague answer. Nothing is clear. We wanted the sketch map, we wanted the trace map of the land, but they are not giving us. Those documents we have annexed.
how much land you are in possession?
Actually I was in possession. At present, they have forcibly taken from me 1 biga 3 kata 19 lesa. That is our patta land, my lord. How can they take it?
There are two persons or one person?
And the petitioners are several persons, wife, widow wife, and the son.
Why are so many
Yes.
petitioners?
They are the sons. One is Hasina Bewa. She is the widow of late Mohiruddin Sheikh. Mufida Begum is the daughter. So Hafizul, Rafizul, all are the sons and daughters of late Mohiruddin Sheikh. So all of them have become petitioners, and their claim is that
They say that you are in possession of 3 kata 6 lechas of land.
no, 2 plots of land are there.
What?
2 plots of land are there. So in
No,
total,
no. Your sale deeds, there are 2 sale deeds.
yes,
One sale deed is in favor of Mohiruddin Sheikh and the other is in favor of,
both are Mohiruddin's name, but it was purchased from 2 persons. That is, one was purchased from late Kurindra Chandra Das, who is the father of respondent number 9, and another was Banaram Das, who is the father of respondent number 8. And now their father sold the land, and the government wants that plot of land to take from me and want to give them on the name of MNTV lands. So how they can take my land? If they want,
you can take the land means the fact that this is government land.
no, how
This is
government,
not
because we
PP
have
land,
purchased.
they are.
It is patta land, my lord. I have purchased it by through registered sale deeds.
Understood, but where is your patta?
No, that I said, my lord, that
No, where is your patta? Show me your patta. This was purchased in 1970, we are in 2026, where is
Yes.
your patta?
that is that I have said that everything was given to the lawyer and he died.
You could, no, that cannot be an excuse.
But thing
That a
is,
lawyer lost it for that. How can this
I have
court
made
look
clear
into this?
statement, my lord. But thing is, when there is registered the sale date, I think the title has been transferred.
No, your registered sale deed is there. I am not on the basis of the registered sale deed, but my question is, this is dark number 164. 164 has been shown to be a government land. So if it is a government land, then where is the question of patta?
No, how it can be government land? Then
How it can be? Because unless you show me your patta, show me your jamabandi. Show me your jamabandi.
No,
which
I understand that. I understand that this should have been
No,
there.
no.
But that is not. But this, where is the by sale deed? Why they are not
Your
giving
sale deed,
the?
a sale deed which is not legible. A sale deed which you are producing is not legible. Then how can I help you out?
That is why, my lord, I asked for certified copy. That is secondary evidence, but they are not giving.
Understood. So therefore, you must have in 1970 after purchasing, you must have mutated your land.
Yes.
Where is your
Should have
land payment receipts? Nothing is there.
Should have been. I understand that.
So this is not the
we
way
have-
how you file your
But
petition.
may I pray one thing? Let them provide me a certified copy of the sale deeds.
This is not your case out here. You file an RTI, do whatever you feel.
RTI you filed. RTI application I have annexed here.
Yes,
Kindly see page
yes
34.
Mr. Sen, what do you say?
Well, I am appearing for the respondent number 889
What is that?
as legal aid counsel, my lord.
Yes,
But
what is
this
this?
land, my lord, in my affidavit in opposition, my lord, we have annexed documents, my lord. Page 66, Annexure J,
Page?
page 66, my lord. And page 67.
Yes.
These are the documents, my lord, by which the land has been allotted to us. My lord, the land is allotted under MNP scheme, Minimum Need Program Scheme, my lord. For those who are
This was done in 1997.
my lord,
This was done in 1997.
No, it is done in
2022, my lord.
No, kindly come to page 56. Annexure F.
66, my lord, 66.
Page 56.
56 was also, my lord, given earlier to my husband. 53, my lord. Page 53, annexure F. It was given certified that land measuring 1 biga 1 katta, dag number 131, village Magurmari, allotted under MNP scheme in the year 1985-86 to Srimati Basanti Das. Basanti Das is here, my lord, arrayed as respondent number 9. This is, my lord, page 53, annexure 5. Then, my lord, annexure D, your lordship will find, my lord, page 49. It was in the year 1985-86, my lord. Certified that has your lordship got it, my lord. 49 page. The possession of the land measuring 1 biga covered by dag number 131-8, Magurmari, is handed over to Gokul Das. Gokul Das is the husband of respondent number 8, my lord. He expired, my lord.
So who is in possession of the land?
We are in possession, absolutely, my lord.
In
Now, my lord,
22.
what has happened? Let me complete, sir. Their claim is that they have purchased a land from us, which we have categorically denied in our written opposition in affidavit. My lord, what we say, we are landless people. The government under the MNP scheme, my lord, in the year 1985 as well as 2022, allotted the land covered by dag number 131 and 165, my lord, which is absolutely different from the dag number as claimed by the petitioner. Now, when the petitioner says that his predecessor purchased the land from us, which we have categorically denied. Now, burden lies on them to prove they have purchased the land, thereafter their name mutated, they have paid land revenue, then, my lord, patta issued in their name, nothing short, my lord. Now, here is a question, my lord, the issue involved, with my all respect, my lord, that it is a purely disputed question of fact. My lord, whether he has purchased, and my lord, your lordship knows, my lord,
But
sale deed,
understood.
sale deed does not,
Mr.
is
Sen,
not a,
all are understood.
is not a conclusive title, my lord. Yes,
All are understood.
my lord,
It is therefore you say the dispute is between you and them.
correct,
It should not have interfered.
correct.
Why is the circle officer then issuing the notice?
Issued notice in the, my lord, can you see the dag number mentioned in the notice? It is not
164.
pertains to the dag number of their sale deed.
Their sale
Lordship-
deed is also 164.
My lord, your lordship kindly see. Their sale deed is, one is dag number, my lord, 128 and 135. 128 dag number, Otian number 2, that is sale deed
And the other is 135.
135. Now, your lordship kindly see the notice. Notice I have annexed, my lord.
Notice is that
In
page 29.
Page 65, my lord.
Page 29.
Page 29, their writ petition, our
No,
affidavit.
all your pages are wrongly marked, but anyways, come to page 29.
29, yes. 164 and 131.
These are not the sale deed.
These are not mentioned in the sale deed. Therefore, there is no cause of action, my lord, for filing the instant writ petition.
So you are in possession of 164 and 131.
165, my lord, as per the last, page 67 and 66.
So you are in possession of
165 tag number
and
land measuring 1 biga, and my lord 164 tag number
village Magurmuri, this is also 1 bighas of land,
So you are being given 2 bighas of
2
land.
bighas land.
That is
Respondent number
164 and 165. And the petitioner's claim is here in respect to doc number 128,
and 135, my lord.
which have nothing to do with 164 and 130.
Absolutely.
Yes, that is correct, madam. But their stand is changing from time to time. For instance, my lord, I am showing, kindly see page 29.
No, Mr. Mahmood, whatever may be, the question is, your doc number is 128 and
Yes.
130. So these have no connection with this notice.
That is why you wanted the chitha, copy of the chitha, copy of the
And that cannot be a ground for challenging the notice.
selling
The
the notice. my
notice
lord.
is being given to you that if you are in illegal possession of 164 and 131, what right do you have out here?
But their stand, kindly see, yes, that is correct, lordship is correct. But here they say 164, later on they have shifted their stand to 165.
No, whatever may be 164, 165, but your right is in respect to doc number 128 and 131.
Yes, that is correct.
128 and
That
135.
number is many times changed by lord.
Your 128 and 135.
As per sale deed, my lord, 128 and 135.
So these are all in respect to one is Khatyan number 2 and the other is Patta
Correct.
number 1,
Correct.
which are obviously different lands.
Yes,
Which have
different.
no connection with 164 on 131. Chalo. Heard, Mr.
That our, that the authority is making something illegally against us by showing their tag numbers in separate time in separate manner. So as we have purchased. this-
Whatever may be, Mr.
128,
Mahmood,
135.
Mr. Mahmood, kindly listen, whatever may be, the fact remains that dark numbers which are mentioned
Yes.
and your corresponding dark numbers in your sale deed are different. One. Secondly, the sale deeds which you are referring to,
Understand.
you don't get head and tail of what it is. It's very difficult. Nobody can read it. Thirdly, you have not produced any document that you got your things mutated.
That could not.
Number 4, there's not a land revenue receipt paid in respect to these dogs. Number 5, whatever may be the
Your lordship is absolutely correct. We have
mainly on the basis
mentioned.
of
The reasons we have mentioned.
wait, take your seat and let me pass the order. Heard Mr. M.U. Mahmood, the
But the
learned
one
counsel
clear,
appearing on
Let
behalf
Mr.
of
Wan,
petitioner.
our tag number may be provided
Mr.
to us.
Mahmood, take your seat. I pass the order. I know how to protect you also. Wait. Heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner. Mr. B.K. Sen, who appears? You appear for BTC. Ms. So-and-so appears on behalf of the BTC. Mr. B.K. Sen appears on behalf of the respondent numbers
8 and 9, my lord.
8 and 9. The present writ petition has been filed by the petitioner challenging the notice dated 19/4/2022, whereby the circle officer, Dotma Revenue Circle, have issued a communication to the petitioner number 1 to the petitioner number 1 and the respondent numbers
8 and 9, my lord. 8 and
8 and 9. That they would be that the encroachers of dark number 164 and dark number 131 of village Magurmari could be evicted in favor of MNP oblique TB holders, bracket MNP TB number 5 and MNP oblique TB number 11 on 27/4/2022. Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioners have submitted that their predecessor in interest have purchased two plots of land. Two plots of land by registered deeds of sale, which are Annexure 1 and Annexure 2 to the petition. Without commenting on the legality or validity of the said deeds of sale, this court finds it relevant to observe that the schedule mentioned in the type copy of Annexure 1 and Annexure 2 shows that the lands in question pertain to Dag number 128 of Khotian number 2, situated at Dihi Phakoriga Magurmari seat. What? Magurmari?
Yes, agreement.
Village. And Dag number 135 of Miyadi Patta number 1 at Revenue Village Magurmari. This the reference to these sale deeds in the petition have, however, no relevance to the impugned notice dated 19/4/2022. Inasmuch as the impugned notice refers to Dag number 164 and Dag number 131. This court further takes note of the report which was submitted by the BTC by filing an affidavit. On 11th of May 2026, wherein it is seen that Dag number 164 is a government khas land at measuring 1 biga 3 katha 6 lectures covered by at measuring so and so, wherein one Basanti Das, wife of Rotan Das, and the predecessor in interest of the petitioners were in possession to the tune of 1 biga and 3 katha 6 lectures respectively. This court also have taken note of the submission of Mr. B.K. Sen, the learned counsel appearing on behalf of the respondents, number 8 and 9, and submitted that in respect of Dag number 164 and Dag number 165, both the respondents have been granted 1 biga each under the MNP scheme, and they are in possession. Upon being handed over in the year 2022, the possession? Huh? 2022. Taking into account that the petitioners have not been able to substantiate any material before this court that they have any conceivable right in respect of DAG number 164 and DAG number 131 of village Magurmari. It is the opinion of this court that the petitioners have no semblance of right. It is the opinion of this court that the petitioners cannot sustain a challenge to the impugned notice dated 19/4/2022. Be it as it may, this court also takes note of that that the petitioner have also sought before the respondent authorities the sketch map oblique trace map and the Jamabandi of the land at measuring 1 bigha 3 kotha 19 lectures covered by Miyadi Patta number 1 of DAG number 135, Kotian number 2 and DAG number 128. The same had not been provided to the petitioner. Mr. Mahmood, the Learning Council submits that from those documents, the petitioner that in view of the deeds of sale, which have been enclosed as Annexure 1 and Annexure 2 to the writ petition, the petitioner have a right to claim, right to seek the trace map as well as the Jamabandi of the said lands. It is the opinion of this court that if the petitioner applies for the copy of the Jamabandi as well as the sketch map or the trace map of the land at measuring 1 bigha 3 katha 19 lectures covered by Miyadi Patta number 1 of DAG number 135 at Revenue Village Magurubari, as well as the land at measuring 1 bigha covered by DAG number 128 of Khottan number 2 situated at Magurmari, village Magurmari, Pukrajar, the petitioner should be granted, should be issued the trace map as well as the Jamabandi upon payment of the prescribed fees. Accordingly, the writ petition therefore stands disposed of with the following observations and directions. Number 1, this court is not inclined to interfere with the notice dated 19/4/2022 for the grounds, for the reasons already aforementioned. Number 2, the petitioner, upon the respondent authorities, more particularly the respondent number 5 and 7. Upon application made by the petitioners for the trace map oblique jamabandi of land at measuring ago kita kolna 1 bigha of so and so and so and so and so and so. Shall provide the trace map as well as the jamabandi in respect to the said land upon payment of the prescribed fee. The said actions, the said exercise be completed by the respondent number 5 and 7 upon submission of the said application, complete in all respects, within 2 months from the date of submission of the said application, complete in all respects.
This is a salary I have produced.
I can't understand, you can also read it.
Hello,
That seems to be the certified copy of the original. Certified.
It is original one. But not so distinct. That is the problem. I could not translate properly.
What is the sale consideration? Something, I think
That
it
is
may be
there.
a
That is there, my lord.
what is the sale consideration? Because your stamp duty is 5.
My lord, it is 70.
So what? No, therefore, no. What I'm saying is there are two. At that point of time, the sale deeds as well as the certified copies of those sale deeds, both you used to make 2 copies.
Yes.
And they used to be signed on both. And then they certify one and give it to you, and the other is given them. This is how used to happen earlier. Nowadays, you have these electronic modes. Anyways, have it. Check.
Obliged me.
Yes, Mr. Goswami.
Lordship, as required to place some documents on record. Lordship, I could not do it. I just pay for 2 weeks.
What is your petition for?
For Lordship, against an order of the ombudsman, Lordship. On the last date, Lordship, I was asked to place some documents on record. I did not do so, Lordship.
Then?
This 2 weeks, Lordship, I'll file the affidavit.
I have not filed it.
I could not file the affidavit. As I have joined only today, Lordship, after more than a month.
Interim order is there.
Yes, Lordship, there is interim.
Huh?
Interim order is there, Lordship.
You don't have the interim order. Interim order has not been extended post 23/3/2026. There is no interim order.
And this may be one person. I have the documents. I could not because
Mr.
I
Arvind
could not come
appearing on
to
behalf
court,
of the
Lordship.
petitioner seeks for further time to bring on record the certain documents. This matter on 11th of October. In the
11th.
meantime, the affidavit in reply, the additional affidavit be brought on. Affidavit file.
My lord,
Yes.
if it, going to file and rejoinder sometime, 1 week time may be granted.
The
Ready already.
Respondent IOCL have filed the affidavit on 28/7/2026. Mr. B.J. Ghosh, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file a reply there against. Accordingly, list this matter on 2nd of November 2026. In the meantime, the reply be filed.
May do, Lordship.
My lord, in this case, on the earlier, last occasion, my lord, an affidavit was filed enclosing a completion certificate stroke progress report, my lord. My lord, as per the earlier affidavit of the chief engineer, there is a balance of 47 lakhs to be paid. That is the admitted position. Now that cannot be made out from here, my lord. I have taken instruction from my client, my lord. He says, my lord, let the payment vouchers be produced, my lord. Only then it can be reconciled, my lord. Because the measurements are done by them, bills are raised in the department, and the payments are made by bank, my lord, transfer. And it relates to, my lord, some years back, my lord. So he's finding it difficult to reconcile. But that 47 lakhs, my lord, it kind of, if your lordship comes to page 175, your lordship will see it's very difficult to measure. So if they produce the payment vouchers.
Mr. Counsel, my question is here. Here they say that the entire amount has been paid. If you file on reconciliation that the amount has not been paid, then it is for you to go before the civil court, not here.
But
In fact, my lord, after the affidavit also I have furnished for written instruction. It says that, my lord, even the balance amount of 2,49,000 that has been paid in March 2024. Nothing remains now, my lord. Lordship will see the calculation, my lord, balance amount 249,944. That has also been paid as per my written instruction.
Where is your affidavit? Where do you say
Yes, ma'am.
entire payment has been made? Project cost was so and so, the petition aggregated so and so, non-depreciable. Where is your statement?
My lord, here, Lordship will find, my lord, para 2, page number 171, running page 171. But when to court's order, my lord, we have filed the additional affidavit, page 171.
Amount of rupees demand and after it was made to the petitioner partially lying to the receipt from
C and D, my lord, clarifies that point.
So if you agree, go before the civil court.
Yes, sir.
That's the only way. Not here.
My prayer is, my lord, let them produce the payment vouchers, my lord. That will, that we can.
Mr. Gustami, you have rendered this court to what? That this court is going to do all these things. No, sorry.
No, this is not even countersigned by the chief engineer, my lord.
This is an affidavit filed by the chief engineer.
My lord, affidavit
This
is
is an
filed by the
affidavit
chief.
filed by the chief engineer. When the chief engineer files an affidavit along with the document, it is deemed that it has the authority of the chief engineer.
The figures do not match, my lord. I have stated, my lord, it is difficult for me to. Payment vouchers, my lord, let them produce, it will be with them, my lord. That will cleanse the issue, my lord.
Heard Mr. B.D. Gustami, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi, the learned standing counsel of the PWD, appears on behalf of the respondents. The petitioner have filed the instant writ petition seeking appropriate directions upon the respondent authorities for payment of an amount of rupees 60,96,496 along with interest at a rate of 10% per annum. A notice was issued by this court pursuant to the filing of the writ petition on 13/5/2024. An affidavit in opposition was filed by the respondent number 2.
There are 9 months. Page 117.
Wherein it is mentioned that the running bill of the work was prepared and as per the quantity of item of work executed at site, up-to-date payment to the petitioner was made was rupees 89,32,823 against his bill value of rupees 136.64697 lakhs. It is further seen that an affidavit in reply was filed by the petitioner wherein at paragraph number 8, the said statement of payment of rupees 89,32,823 lakhs have not been denied. This court also takes note of a further additional affidavit filed by the respondent number 2 on 6th of August 2026, wherein it is mentioned that against the total bill of rupees 1,36,64,697, was paid to the petitioner partially time to time after receipt of the aforesaid. After deducting the necessary deductions. A completion certificate have also been enclosed as Annexure A to the said additional affidavit. Showing inter alia that the petitioner have been paid the total amount of rupees 1,36,64,699 697.
97.
Mr. B.T. Goswami, the learned counsel appearing on behalf of the petitioner submits that though he tried to obtain instructions from his counsel, from the client, from the petitioner, as regards the payments so made, but such reconciliation could not be carried out on account of appropriate documents not being available.
Payment voucher. Payment voucher.
Appropriate document will include.
Well, only one thing I would like to point out, madam. Madam, your lordship will kindly see the first affidavit is of 2025, filed by them. Now, my lord, they say that payment was made in 24, my lord. Your lordship will kindly 5/8.
Taking into account the above, it is the opinion of this court that the present petition can be closed. In view of the stance so taken by the respondent authorities, more particularly in the additional affidavit filed by the chief engineer on 6th of August 2026. However, by doing so, by further granting certain liberty to the petitioner, accordingly, the writ petition therefore stands disposed of with the following observations
just
and
one prayer, my lord.
directions. Taking into account the stand which have been taken by the respondents PWD by filing the affidavit, that the total amount of rupees so and so, 1 crore 36 so and so, have been paid to the petitioner after deduction of necessary tax, after carrying out the necessary deductions. 1 crore 36 64 697. The said amount, this court cannot pass a direction upon the respondents to make further payment to the petitioner.
Well, they themselves have taken two stands, my lord, in their two affidavits, man.
This court, however, finds it very relevant that this court, taking into account that the petitioner have not been able to reconcile the accounts and the stand, and it is the specific stand that the petitioner have been paid the said amounts of rupees so and so. This court directs the chief engineer. What is the respondent number?
Will be, my lord.
The respondent number 2. Upon production of a certified copy of the instant order to provide the petitioner the payment vouchers so that the petitioner can reconcile with his accounts. The said exercise be carried out within 30 days from the date of submission of the certified copy.
Much of them. Look, they have filed two affidavits, my lord. The first affidavit by the chief engineer says, my lord, 47 is awaited, my lord. Payment of 40. Now it says, referring to the this paper, I have been handed over, that in 24 itself, this payment has been made.
They will provide.
Yes, man. That will do.
Before parting with the record, if it is observed that if the payment vouchers so provided to the petitioner upon reconciliation does not amount to the payment which is stated to have been made by the respondent authorities, the same act, the said would be construed to be an false undertaking being given before this court. On this basis, if you have not been paid, you would get it.
My lord, I thought, my lord, your lordship would allow me liberty to come back again, my lord.
Mr. Counsel, false undertaking, you know what is the consequences.
No, my lord, it is difficult, your lordship.
Mr. Goswami, you are not understanding. I have said that it will be a false undertaking.
By them, by them, man. Yes. The two stands they have taken, my lord, referring to now saying, my lord, in 24 itself they have paid the amount.
Stand taken before this. Undertaking must stand.
Not so bad.
Yes, what is this?
May please, Lordship. Lordship may kindly see last order 27/7/26 order.
Whether the land under the occupation of falls under Lakhimpur Municipal Board and further as to whether any steps for eviction against the petitioner has been taken, more particularly in view of the land being reserved for Lakhimpur Municipal. After verification of the office record, it is found that dark number so and so measuring and so. falling under Mansur, so and so is a government land categorized as type and it is evident that but
Lakshipur Revenue Circle.
so therefore
287 belongs to the municipal authority.
but
He is
it
into
does not
90.
fall within the municipality area. So therefore, there are two ways out of it. If it is not being allotted, you can take very well steps against for eviction as per permissible in the law. But the municipality cannot take.
But the instructions, instruction whatever my plan is, so let it come on record by when way of an affidavit. Number one, and secondly, in fact, the land was allotted, SDLC minute is there on record. So they have to ultimately say, when the land has been given,
If the land is allotted but not settled, Mr. You want an early eviction or late eviction?
early eviction.
So if it is early eviction, then 18 will apply. If it is not settled. If it is settled, then you have to file a suit. Get the point? There's a difference. You want to file it affidavit?
If your lordship directs, in that case, I have to file. Otherwise, lordship, as because the municipal land falls in 287, he is occupying 294. Paragraph number 2.
Indeed, none of the DAG mentioned in the letter, that is 287, 287, 2/94 does not fall in municipality area. There's no quarrel with that. But here is there was served by Lakhimpur board falls within DAG number so and so, which is recorded as a government land.
Yes.
And recorded possessor is Foliamari High School. It does not fall in DAG number 287-2. It is noteworthy that the land does not fall within the municipality jurisdiction. Indeed, the DAG land in the letter so and so does fall in the municipality area. Office of the undersigned has neither taken any steps for eviction nor it is a knowledge of a area of Lakhimpur board. So there are two ways I can set aside this thing. You have no business.
School land is different.
Page 21.
In fact, in the photographs which we have annexed, that photographs will show.
You are in, he is in DAG number 294.
287.
Huh? No, petitioner
He is claiming in 287, but actually he is in 294.
287.
Second page, lordship, if your lordship comes to the second page, this is a vernacular one. May I read, lordship?
Yes.
মহাশয় উপৰোক্ত বিষয় ও প্ৰসংগ সন্দৰ্ভত সন্মান সহকাৰে আপোনাক জনাও যে নুৰুল ইছলাম পিতা সোয়েনছো লক্ষীপুৰ ৰাজচক্ৰ অন্তৰ্গত মানহপাৰা ৰাজগাঁৱৰ বাসিন্দা হয়। যোৱা ইংৰাজী 16/5/2024 ইংৰাজী তাৰিখে লক্ষীপুৰ পৌৰসভা কাৰ্যালয়ৰ পৰা অবৈধভাৱে ঘৰ বনোৱাৰ জাননী জাৰি কৰে আৰু 2 দিনৰ ভিতৰত ঘৰ খালী কৰাৰ নিৰ্দেশ দিয়ে। সৰজমিন তদন্তক্ৰমে দেখা যায় যে লক্ষীপুৰ ৰাজচক্ৰ অন্তৰ্গত মানাহপাৰা ৰিজাৰ্ভ গাঁৱৰ 294 নম্বৰ চৰকাৰী দাগৰ অংশ জমিত নুৰুল ইছলাম পিতা সোয়েনছোৱে দোকান ঘৰ সাজি ব্যৱসায় কৰি থকা দেখা যায়। উক্ত দোকান ঘৰটো লক্ষীপুৰ পৌৰসভা এলেকাৰ বাহিৰৰ হয় বুলি জনা যায়।
So he is in DAG number 294. Part.
No, part. Lordship, kindly see my record. Page 12 is the sale deed, lordship. Then page 15,
But he is
revenue
occupying
payment received.
in
And
294.
Page 16 is the Kesa Patta, lordship.
Who has issued Kesa Patta to you?
Lordship, may kindly see. Page 18, the vernacular.
What? How can a Kesa Patta be issued to you?
Sita copy, lordship. Sita copy, page 20 vernacular. Sita copy.
It is given by Mondal. He has no authority to give this type of.
The Dag number is mentioned here, Lordship.
You are in possession 287-2.
Yes, Lordship, 287.
Sorry. One kotha 5 lecha
Yes, Lordship.
or 3 kotha 5 lecha.
1 kata 5 less.
Are you sure?
Lordship.
3 kotha.
1 kata 15 less, Lordship. 1
One
kata
kotha
15.
15 lecha.
15 less, yes.
What is this? Nokari. Anyways, you are in 287,
Yes.
isn't it?
287 is not mentioned in the notification
No,
from
we have,
1971.
we are, this executive officer, Lakhipur Municipal Board have issued. He has no jurisdiction. Matter is over. So we dispose it of on Thursday at 2 p.m. for final disposal.
Lordship will keep that as a part
Huh?
on that day. I will place it on that day or today itself.
Now only. Mr. H. Sharma, the learned additional senior government advocate, have placed before this court pursuant to the order passed by this court on 27/7/2026, an instruction issued by the Circle Officer, Lakhipur Revenue Circle, wherein it is stated that the land wherein the petitioner is in possession does not fall within the Lakhipur municipality area. The said instruction is kept on record and marked with the letter X. Taking into account the above, list this matter on Thursday at 3 p.m. for final disposal.
Obliged.
Not that day order, no, what is that? Food corporation, what?
Targeted public
Huh?
targeted public distribution.
Ask your DC not to progress because you see that day I dictated. Then it became 15th August. I'm yet to see the type copy of the order.
Tomorrow is the last date for submission.
But unless you issue the corrigendum,
That's true, but
because if you are corrigendum, you are limiting everybody.
because Lordship has set aside 2 clauses. Lordship has set aside 2 clauses of the NIT. So the order needs to be covered.
No, you see, the thing is like this. The upper 7-1, it is the authorized who can take it.
Lordship.
Now, if it is being taken by the DC to himself, and from the DC is being lifted, it can be done. Then it is okay. But if it is not done so, then it goes foul to 7-1. So therefore, that is the issue out there. So the problem is I'm yet to get the copy with my hand because it happened on that day. Then everybody left, taking into account that it was 15th August is closed, 15th is closed, 16th, today is 17. I hope now I get it. By tomorrow only you will get it, huh?
In fact, today another reparation has been moved, challenging the same NIT by another private party. I have mentioned before the Honorable Court that already the Honorable Court has passed an order. And the matter is fixed tomorrow.
Tomorrow. Let's see if I can get it. I'll ask my for once it is being done today, so I rise if it is corrected and done, then to send you a copy. You can take it up.
I have already telephonically informed them.
The only problem is for you, you can very well do the transportation here. Or if you could have bifurcated the tier 2, then it would have been permissible. But with tier 1 and tier 2 being a composite contract, that becomes the difficulty. Yes, what is this?
this matter pertains to transfer of prisoners to Manipur.
What happened?
I have received instruction, my lord, there, Lordship may be pleased to peruse it. But our state, my lord, stand is that we have not received anything from Manipur government, my lord. Even we wrote twice, my lord,
Update be provided, yes.
wrote twice, my lord. But this was the,
To reveal the consent of you for transfer of the 2 lakhs from the first one. Even no official have been received from the government of Manipur by the government in that. Yes, why you are not providing it?
In that case, I shall find out the, what is, and accordingly, I shall inform the today's status and to pursue about that, to intimate according to the laws.
Ms. Yuda, the learned counsel, additional senior government advocate have placed before this court an instruction dated 31/7/2026, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is apparent that on account of the official communication having not been received from the state of Manipur, the respondents in the state of Assam is not in a position to act. Mr. N. Anik Singh, the learned counsel appearing on behalf of the petition, the respondent appearing on behalf of the state of Manipur, submits that he would take it up with the respondent authorities in the state of Manipur. Taking into account the above, list this matter on 11th of September 2026 for an update.
nice.
Yeah, please, Lordship. This is non-payment manner by the BTC authorities.
Lordship, I pray for some time to obtain instruction in this matter, my lord.
What is this?
I constructed my lord, a building, my lords, for a total amount of 8 crores something, out of which 5 crores has been
BTC?
paid.
Lordship.
Okay, 1 month verification and 6 months. If he is entitled, pay as per Tamsir Ali. You follow Tamsir Ali.
Yes.
Verify within 1 month and then pay as per Tamsir.
Obliged.
Obliged.
Yes, what is this, Mr. Gugoi?
My lords, there's an allegation upon us that we occupied the land of the petitioner without any acquisition and install a JJM mission, but I have some instructions that land was handed over by the circle officer to us. We didn't act on our own.
Circle officer is a party.
Yes, my lord, that's
Yes,
point
yes.
number 6.
What is your
My own land has been taken away, my lord.
You file your affidavit saying that the circle officer.
Last
has given-
opportunity was given, my
My
lord.
lords, that is evident, my
2025
lords, that,
petition.
no, my lord, we have not filed, but that is
Final
evident.
opportunity is granted to PHC as well as there to bring on record. Have you filed your affidavit?
No, my lords,
But
but
we can't take your thing.
no, my lords, it's evident from the petition itself. It's what are the state, the fact which I'm stating.
Therefore, you are not going to file your affidavit.
We'll file, my lord, but
No, you cannot.
my lords, but it's 9, paragraph 9, my lords.
No, forget
Page
about
11.
it. Petition 9 is not there. Circle officer.
Circle officer gave us that land trust, my lords.
Yes, circle officer, what authority circle officer has got
Ah,
to hand over my land?
yes. Who is the circle officer?
What does it?
Biswanath Revenue
It-
Circle.
it-
Why haven't you filed your affidavit?
Lordship, we have not received any instruction. Most probably, Lordship, somehow the letter has also not been sent.
Stop. The circle officer, Biswanath,
Yes,
it is the stand of the PHE. Mr. D. Gogoi, the learned counsel appearing on behalf of the PHE department submits that the PHE have constructed, what did they construct?
Even Jal Jeevan Mission building.
The Jal Jeevan Mission building over the land on the basis of the said land having been handed over by the circle officer, Biswanath Revenue Circle. Mr. H. Sharma, the learned additional senior government advocate who appears on behalf of the respondent number 6 shall obtain or shall take appropriate instructions and file an affidavit through the circle officer as to under what authority the petitioner's land was handed over to the PHE department. First up, the affidavit be filed on or before 3rd of September 2026. List the matter on 9th of September 2026.
Wait, Lordship. So in case Lordship, contacting advocate is on lug, Lordship, kindly adjourn the matter.
Yeah?
Days. Kindly matter may be taken up day after tomorrow, Lordship.
No. What is the matter about?
Lordship,
You want some time?
yes. Lordship.
Okay. There's no urgency, no interim order.
No, no.
The council appearing on what have you challenged?
He is basically challenging the inaction of the district judge in this, he is not disposing of his appeal under Assam First Regulation 49C. So maintenance issue was kept open, my lords. That is 226.
Custody of the elephant.
Yes, ma'am.
Okay.
District judge.
The district judge has already passed the order. Yeah. The council appearing on behalf of the petitioner seeks for an accommodation. First of, it is seen that on the earlier occasion also the petitioner council have sought for time. In such circumstances, it does not appear that there is any urgency in the proceedings for which the petition will be directed to be listed on 13th of November 2026.
Yeah, please, Your Lordship. Lordship, matter regarding non-payment of contractor's bill.
Where is the other side?
M. Sutia appeared. They filed their affidavit, Lordship. Page 33 is there.
Which department?
It is by the BTC and Deputy Commissioner Kokrajar is the authority.
What do they say?
Page 33. They have submitted their requisition before the Joint Secretary, Government of Assam, Home and Political Department.
Whether the deponent begs to say the proposal for release of it to clear outstanding liability of the pension amount as for the so and so have been already submitted to the government.
They have submitted a collective bill. My amount is 12 lakhs 3,473.
Huh?
They have submitted a collective submission.
Where is your case?
My amount is 12 lakh 3,473.
Where is it? Is it by? For what purpose is this?
We have supplied petroleum products to the CRPF.
Yes, what is your stand, BTC? Oh, government, home and political. What have you taken?
Malat, though I am representing Malat.
Understood. BTC says that the payment has to be made by the home and political.
Political, yes, Malat.
What is your stand on the basis of the affidavit?
Mal-
Miss Yudas, the learned additional senior government advocate, Lehok.
Malat, we have.
Miss Yudas, the learned additional senior government advocate, submits that she will obtain instructions
Malat, from
as to the proposal submitted by the Deputy Commissioner Kokrajar, making a
Yes, Malat, 63. Lordship will find in annex, Malat, 34.
seeking fund requirement of the pending liabilities,
Malat,
which was submitted on 18/7/2024 and 13/9/2024.
Yes. That's 34.
List this matter again on 18th of September 2026.
9. 6.
And madam, your affidavit is not clear whether the petitioner is entitled to the amount or not, how much?
Lordship, we are not in this matter, my lord. The government, the deputy commissioner will be They will be appearing.
Ah, yes.
We are not the authority.
No, no, why the affidavit who, you have filed the affidavit,
My
why it is not clear as to whether the petitioner is entitled to the amount or not? He is claiming certain amount.
lord.
What do you say in the affidavit? That we have sent all the pending bills. You should have come up with this.
Petition is not, I'll.
So in addition to that, the respondent number 3, na? This is what?
Three. 2 and 3 has filed. 3, this is 2
is
and
that?
additional district commissioner.
No, no, respondent number 2. The respondent number 2 shall also bring on record his stand as to what is the amount to which the petitioner is actually entitled to by filing an additional affidavit.
My lord, deeply obvious.
Yes, what is this?
My lord, this is the
Yeah.
challenging, my lord, their communication regarding, my lord, the cancellation of the NIT, my lord, because we, an NIT was issued on 5/9/2024, my lord, lordship. And we are, my lord, technically qualified, then we are L1 also, my lord. Then, my lord, letter of acceptance was also accepted, we paid the performance security deposit also, my lord. And thereafter, my lord, they decided to, contract also signed, my lord. So decided to cancel the NIT, my lord. Not to issue the work order, my lord. So assailing that, my lord, we filed a writ petition, my lord. In this, then, my lord, in that writ petition, they submitted an instruction, my lord.
No, my question is, did you submit in pursuance to the liberty granted by me? No.
No, my lord, no, no, we will not.
So now you are challenging, there is no stay.
My lord, there is, subject to outcome, that's all, my lord.
Where is the subject to outcome?
My lord.
There is no subject to outcome.
There is an order, my, I'm told myself.
Subject to outcome.
My lord.
What is the contract for?
Contract from, my lord, the construction of lordship, road from Jalapur Rambai Road to Kalinchera BSF camp via Nutanpur Garden LP School.
When is it getting completed?
9 months, my lord.
9 months is over.
No, my lord. In fact, my lord, so far as this particular work is concerned, my lord, that tender process is not over, my lord, in the fresh tender.
Huh?
It's not over. Tender process has not been completed, my lord.
Not completed.
Not completed.
Okay.
There are 2 items, my lord. The other item, my lord, work order has been issued, to my knowledge. In the fresh tender.
No urgency.
Urgency is there.
Work is being
We
given.
have stake material also there, my lord. After site was physically handed over to us also, my lord. Then, my lord, all on a sudden they take a decision to retender.
They issued the letter of intent.
My lord.
If they issued the letter of acceptance, work order?
Yes, yes. Letter of acceptance they issued, my lord. We were alone letter. Then they decided, my lord, to go for a retender. And this honorable court has passed on direction. So why our work order should not be issued? That was never communicated to us. What they said is that, my lord, why you go for a retender? So that was not a issue before this honorable court, my lord. This honorable court directed them to furnish a reason why we did not go with the formal work order. A letter of acceptance was given, site was handed over to us, agreement was signed, my lord.
We have it on a day which can. Let's try our luck on 3rd of September.
Lordship.
Only thing, my lord, I pray for, my lord, a liberty to file one additional affidavit to bring in the parawise comment that I have furnished in the first writ petition. There, my lord, the entire grounds was given. Considering that ground, my lord, the earlier writ petition was closed.
Please list this matter on 3rd of September at 2 p.m. for final disposal. In the meantime, liberty granted to the PWD to bring on record to file an additional affidavit on or before 24th of August.
Well, if you got, they may deduce the record of the case, my lord. Because that may be record with the case, record of the case, my lord.
On the next day, the records of the case of the contracts in question, which led to the cancellation of the LOI. LOI or LOA?
LOA, my lord.
Lesser of acceptance, my lord.
Be pleased before this court.
Lordship.
Contractual use, Lord.
Which, from where?
Lordship, it was the executed under the SDF scheme, Lordship.
Huh?
SDF scheme, Lordship. It was implemented by the PWD, Lordship, in the district of Dhemaji, Lordship.
Non-payment of?
Contractual use, Lordship.
Hello. Verify and then, what is your stand?
My lord, on the last occasion, I was directed to, my lord, have instructions of regarding one communication that is 12th of June 2026 furnished by the Revenue Department. They say, my lord, the estimate of the work has not been received by the Deputy Commissioner. My lord, this is the estimate that was furnished, my lord. Lordship will see the next page.
So the PWD, as per PWD, he is entitled to the amount.
No, only, my lord, we have placed the, my lord, estimate. Now it is the Deputy Commissioner will have to verify and make the payment. Estimate we have placed.
We have filed the affidavit the next time, my lord, we have asked for that.
And what is the respondent, who is the AR?
It will be the revenue.
Respondent number?
Yes. It is the, my lord. Respondent
Deputy Commissioner is who?
6 and 7, my lord.
When I filed it,
What do they say?
says that we have got the amount of, my lord, that 59 lakhs 2014, 21,400, my lord,
Yes, it was.
for payment of the, my lord, particular work.
Have you carried out the, was the work done?
Yes, sir.
Work done.
Work done, Lordship. It was admitted, Lord, by the Chief Engineer also, Lordship.
Scheme has not been sanctioned by the government.
Yes, it will have to be sanctioned, my lord, pursuant to this estimate. My lord. And they say, my lord, they are waiting for the estimate, but we have provided the estimate way back in, my lord, 31/10/2023.
What is your instruction?
We have already submitted that.
Now, you have not been able to place it before the State Executive Committee on account of non-receipt of the estimate and other relevant documents from the PWD. Now, has the PWD provided to them or not?
My lord, so far as this, my lord, estimate is concerned, that I have got the instruction, I have placed it, my lord.
I am not the SEC.
Lordship.
SEC is them.
Yes.
Have you provided the estimate and other relevant documents from the? Have you provided or not?
That part, my lord, 31/10, my lord, estimate is there. So far as any other document, my lord, they will coordinate and, my lord, finalize the issue, my lord. Lordship will dispose it of in that direction. Between, my lord, PWD and the Deputy Commissioner, my lord, Executive Engineer, he will have to furnish whatever is required. Definitely he will furnish, my lord. Because, my lord, Lordship will see page 52 for a moment of the writ petition.
No. The instant writ petition has been filed by the petitioner being aggrieved by the non-payment of the dues which the petitioner is entitled to from the respondent authorities. It is seen that the contract work order which was issued to the petitioner by the district commissioner, Dhemaji, was in pursuance to the powers conferred under section 50 of the, what is that act?
Disaster Management Act, Lordship.
What is the act name? Section 50 of the
Disaster Management Act, Lordship.
disaster management?
Disaster Management
Madam.
Act, Lordship.
What is that act name?
State disaster. SDRF.
No, section 50 is an act. Under section 50 of the,
Disaster Management Act, 2005, Lordship.
Huh?
Disaster Management Act, 2005.
of the Disaster Management Act 2005. Stop. The respondent number 7 has filed an affidavit wherein the amount as claimed by the petitioner have been duly admitted. However, on account of the approval not received from the Revenue Department, Revenue and Disaster Management Department, and the fund and approval and sanction not received from the Revenue and Disaster Management Department, the payment could not be made to the petitioner. Court also takes note of a communication issued by the from the additional secretary to the government of Assam, Revenue and Disaster Management Department, dated 12th of June 2026, wherein it is mentioned that the SDRF proposals needs to be approved by the State Executive Committee for release of funds against executed works. It is also mentioned that a proposal could not be placed to the State Executive Committee on account of non-receipt of the estimate and other relevant documents from the executing department, that is the PWD. The said instruction is kept on record and marked with the letter X. This court fixes this matter again on 25th of September 2026. In the meantime, the PWD department, in the meantime, the PWD authorities are directed to take effective steps for submission of the estimate as well as the other relevant documents to the Revenue and Disaster Management Department so that the same can be placed before the State Executive Committee. On the next date, an update be placed by both the Revenue and Disaster Management Department as well as the District Commissioner, Dhemaji, no?
Dhemaji, Lordship. Public.
Well, the instructions are awaited, madam, in this case, Mr. More,
But if the representations are disposed of,
extra copy in it.
I don't understand one thing. He has submitted an application in 2023. Why it is not been disposed of? Either you reject, do whatever it is. We can't sit on it.
I'll get a status, my lords, of this application.
The instant writ petition has been listed after issuance of notice on 25/9/2025. The grievance of the petitioner in the instant writ petition is that the petitioner had submitted an application before the circle officer, Polasbury Revenue Circle, for deletion of the names of certain persons whose names have been inserted by removing the name of the petitioner.
There are some other person's names also.
For deletion of the names of some other persons in the record of rights of a plot of land which belongs to the petitioner. The said application having not been considered since 2023, the petitioner had approached this court in the year 2025. Mr. Endas, the learned counsel appearing on behalf of the state, appearing on behalf of the circle officer, Polasbury Revenue Circle, submits that he will place necessary instructions in that regard. Is this matter again on 28th of August 2026. In the meantime, on the next date, the instructions be placed without fail.
My lord, the extra copies has not been served till date.
We will serve, Lordship, we'll serve it.
An extra copy of the writ petition be served by tomorrow. IMFL, what is this?
I was the H1 bidder, my lord. License was granted. Now the NOC is not being issued by the municipal board. If your lordship kindly perusses the order at 5/6, my lord. Because the grounds on which it has been rejected.
Rejected?
I mean, they are not issuing the NOC, the municipal board.
The municipal board.
Which municipality?
Polasbury Municipal Board. File our affidavit, madam, because there are
You are
complaints.
Polasbury Municipal Board.
Hello.
Why you are not issuing?
Complaints, madam, we have filed.
Anyway, you have don't issue.
Madam,
Reject it. Have you rejected or not?
we only cannot issue, we can reject it. By not issuing means, madam, we are not.
No, he must have submitted an application. You don't give it in thin air. Would you give it to Mr. R.R. Gogoi? No,
No, nobody, madam, no.
he has to apply.
Before us, madam,
Or you just go say, anybody wants a particular NOC, I give it to you. Is it something like that? No.
Polasbury, there is no, madam, IMFL off license, shop. Entire Polasbury.
So try it.
Reject it. But in Polasbury, there shall be no liquor licenses.
No certificate.
On or off.
On, madam,
This is an off license.
Off license.
off license, this is on.
On.
On the license.
Hello. You have filed your affidavit.
Madam, I have filed, madam.
Polasbury.
Polasbury has filed a lordship.
And what is your stand?
Madam, that we have enforced the, madam, all the.
There are objections.
Madam,
There are complaints, that is why they are not giving. There are complaints, that is the stand.
yes, madam. That's why we can't, madam.
Then
And there is a report of the excise department, my lord, that the complaint is malafide, in fact.
865.
I am not going to that extent, my lord. Because the stand is rehearse the rules, my lord. Because ultimately, if they have any objection, those objections are to be placed before the district collector, my lord. The collector will take a call. That is why the last order was passed, my lord.
As per last order, madam, we have also filed the, madam, again, madam, representation before the district commissioner, madam. So they haven't received any reply from them, madam. As per last order, madam, they approach with all the bodies who has filed the objection, madam, that no license can be, NOC can be issued, madam, with all the authorities, madam. all the institutions, committee, all are they all went to district commissioner office of the district commission. Because it's not only chairman, chairman is not taking a decision alone, all the puja committees and all we have hired managed the affidavit, all the objections by the
Okay, whatever, we bring it by way of an additional affidavit.
it's already, yes,
No, don't bring anything else. Who appears for the DC? Is the DC a party?
this is my,
Respond
Problem is,
it's,
the same council appears for DC. Yes.
Well, because direction was not to, only to file the representation before the district commissioner. So accordingly, the Polisbury Municipal Board along.
Now, has the district collector taken a decision?
Not now, till now, my lord. They have not.
Now, isn't the order of 5/6/2026 an order passed where instruction is being sought from Miss Yudas on the basis thereof?
My lord. No, it is,
It is one on.
Polisbury Municipal Board.
Understood, but unless the DC's section is not, decision is not there, how can you take?
This is to take decision.
See, Miss Yudas, the learned counsel appearing on so and so on next date shall receive instructions in writing from the chairman of so and so as to the steps they propose to take once the decision is arrived at in the matter by the district collector.
You will read the first paragraph also.
Understood, but first, without the decision, how can they think what is to their?
That is what they were supposed to place it before the district collector, whether they have done it or not, my lord. Now, then it is for the district collector to take a call now, my lord.
But this is something else.
On 8 June, my lord, they all.
This direction is what the Polisbury Municipal Board will do pursuant to the DC.
Yes, pursuant to the DC. First, they will place it before the DC, then DC will take a call, and what is theirs then?
It is seen that the Polisbury Municipal Board had submitted the resolution taken on 6/6/2026 to the District Commissioner Kamrup Rural. Mr. H. Sharma, the learned additional senior government advocate, shall apprise this court on the next date as to whether the District Commissioner Kamrup Rural have taken any decision on the said communication dated 8/8/2026 issued by the chairperson, Polisbury Municipal Board. To establish this matter on 16th of September 2026. Yes, Miss, other matters we don't know. Miss G. Goswami, what is your matter? Tell me. Other matter, other council. Everything.
We have two matters together. One is item 54, one is 43. Item 54 is that matter relating to NC Hills Lordship, that Mahabal Cements, the land allotment.
What happened today?
That matter, we have filed an affidavit, so let that matter may be taken up on some other day, Lordship. There is no urgency from our side, but one direction was there that we have to file affidavit. We have accordingly filed the area of cultivation.
Madam, what happened in that case as regards where you sought to take instruction that that particular company is not there, some other company is coming?
Yes, Mahabal is taken over by DK Lakshmi.
So it is by way of acquisition, means amalgamation or?
Actually, what is the history? No. What happened is the mining lease initially was in the name of a consortium, part of which was Mahabal. And therefore the lease for the cement company also was in the name of Mahabal. That mining MDO was cancelled because I think the state took over AMDC, and thereafter the next NIT which happened this year, JK Lakshmi participated.
No,
So now
therefore,
JK
what,
Lakshmi
no, we see, I'm not on mining lease.
Yes.
Mining
Yeah,
lease has nothing.
part of this.
Your case was for demarcation.
Correct, correct.
Now, your case was, you last time said that now that
Muhammad
lease
says
will
to be
now be
lease,
granted
JK
to
Lakshmi
JK
is the
Lakshmi.
lease, correct.
So therefore,
We have
you
really
were supposed to either amend or file a fresh writ petition,
for protection.
whatever may be, but because once Mahabal is out, unless you challenge the
Yes, Your Lordship.
cancellation, you don't have a
Yes.
locus.
Problem is that instructions from the client is delayed because there's some personal reasons. In the course of the week, we will be filing it. Yes, we'll be filing it. We'll file an affidavit bringing on record, and then we file an impediment in Sonesh Hojai.
In their cases, I'm not on concern. In
And
your writ
fresh
petition.
writ petition for protection while doing demarcation.
Yeah, so therefore you
That
need
is-
to
that-
file it.
yes,
Last time, therefore, I
There's
said to you.
personal problem with the general counsel. He's got some health issues, so we've now got proper instructions, so.
So you need to file that application, petition,
writ
because this petition, in
Have
view
you
of,
said?
unless you challenge the cancellation of the lease, which you are not.
No, he is not.
No. Now, when the lease which was granted to you, the land lease was granted to you, have been now been given, must have been cancelled.
Yes, Your Lordship, yes, yes,
Give it to somebody else.
yes,
So therefore you lose the locus.
yes, Your Lordship, yes,
So
absolutely
your
correct.
petition no longer survives.
Absolutely, there are no two ways about it, which is why I need to
Therefore,
file.
your petition, I'm closing it right away now.
Mahabal,
And the other petition will continue, we'll look into it, whatever it is. But your petition, therefore, you need to file a separate
Yes,
writ
Your Lordship.
petition. If you want a protection, but your prayer was that these people were not demarcating it.
No. Lordship, what happened is when we got possession, they were demarcating, the locals came in and caused.
And
a
they were
ruckus.
not providing
They were
the,
not providing, yeah, the council.
so
was
now you
registering-
don't have a.
No, that everything is so far all good. But we might still want to continue protection, so what can from your lordship, we will file a writ petition.
You may have,
Lordship will give us liberty to file.
Miss,
No, actually, no. it's a-
you are not here.
Yes, no, no, Lordship, yes.
You are not before this court. How can I grant a liberty to you?
No, yes.
Mr. G. Goswami, the learned senior counsel, is listed by so-and-so, appearing on behalf of the petitioner, submits that in the meantime, the lease which was granted in favor of the petitioner have been cancelled and a fresh lease has been granted in favor of its, you have a,
JK Lakshmi Cement, J,
and is it anywhere connected with you, legally speaking?
my parent company. I'm
The
100%
parent company, of the petitioner. What is this parent company? Anything legally, is it a parent company?
I'm 100% subsidiary, yes. Of JK Lakshmi Cement.
No, is the concept of a legal company, a parent company? In
Yes,
legal.
yes.
Show me which provision of the Companies Act says parent company.
Holding company, they call it.
It cannot happen.
Companies Act.
And then no parent company. I've never heard about a parent company. Parent company, we say it in outside the courtroom, not inside.
We are
Fully
100%,
subsidiary,
yeah,
there
we
might be a
100%.
fully subsidiary company.
100% subsidiary.
You may say that, but no parent company, parent mother, father company, how?
Holding company, they say it, I think, 100% holding. Not parent, holding company perhaps.
Holding company?
Yeah.
A holding company in relation to one or more other company means a company of which such companies are subsidiary companies. For the purpose of this clause, the expression company means a year.
Lordship has 246.
246, holding company. Who will be the holding company?
JK Lakshmi Cement. They hold 100% shares in Mahabal.
It's that the lease have been granted fresh lease has been granted in favor of its holding company, namely JK Lakshmi Cement, huh? What's the full name?
JK Lakshmi Cement.
Cement. No limited, nothing. You have to give it. This is a court's order.
JK Lakshmi Cement Limited.
Because tomorrow the limited. Stop.
JK Lakshmi Cement Limited.
Taking into account the above, the present proceedings, the present writ petition cannot be proceeded with, inasmuch as the petitioner no longer holds a cause of action in respect to the lease which was granted. Accordingly, the writ petition stands closed. It is however observed that the closure of the instant writ petition shall not affect the rights of the holding company of the petitioner, namely so-and-so, to approach the court if so advised.
Obliged.
Our date may be recorded by Excel.
Yes, yes. So-and-so. Okay, now what is this? It will. Yes, your matter, we'll take it on some other day.
Lordship.
We'll fix another day. When do you want it? Yes,
Lordship.
Advocate General, when do you want it? You are
Day
busy.
after tomorrow or maybe.
Day after tomorrow, you have got other matters in this court only.
We are not in a hurry, Lordship, may fix any day.
Lordship, they have filed a affidavit and then they have shown that 6 of the petitioners are within the allotted area, Lordship. And then there are 6 more petitioners. So I would like to file an affidavit with geotagged photos to show whether all the petitioners are within that area. Lordship.
When?
In fact, none of them are within the area. They have some cultivation. We have given the names. 18 persons are having cultivation in that area. There is no human habitation. No house.
No,
nothing. The back end
no,
then,
Mr. Advocate
they have
General,
some
my
joint
question
cultivation.
is here that
27
whether
acres land
they
are
they are residing out there or not, if it belongs to the state also, when they have cultivation also, they are having certain easementary rights. So some compensation if can be granted, that is the issue. No, my question is that is what I am saying, that how something needs to be, because we see in many land acquisition cases also wherein people who are residing in government lands, whenever the houses are being broken, then also they are given zirat compensation, but not for the land. So these are things which needs to be thought about. Anyway, we'll take it on some other day. It is submitted that the North Kachar NC Hills, North Kachar Hills Autonomous Council have filed an affidavit in pursuance to the order passed on so-and-so. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that opportunity may be granted to him to file a reply to the same. List this matter again on 18 September. 18 September.
So for the second matter is concerned.
This matter.
Will take some time for them to submit and will also need some time.
I'm surprised why you are here.
No, for the Mahabal matter, Lordship, that has. So,
Well, one is closed. Good riddance.
so I can leave, Lordship. So my colleague will be here. You will note down. My reply may be given on some other day, subject to convenience of the. I leave.
Yes, others may go.
This one. Lordship, may I please, Lordship? Yeah. Lordship, the petitioners were awarded the tender in March 2025. Lordship, we manufacture and supply what is called the truck mounted hydraulic wire line linch. Basically, Your Lordship, in a producing well, there is some kind of a coating that happens. And we provide the lynch.
Now tell me,
that-
no, only my question is out here. Our scope of interference is limited.
Absolutely, Your Lordship.
So therefore, on what
Yes,
grounds?
let me take you straight away to the banning order and what the problems with the banning order is. And my submission is the banning order is against their own banning policy. 243, Your Lordship. Lordship has 243?
Yes, sir.
Yes. Lordship, this is the order passed, whereas a notice. Lordship is okay with my voice? It's not echoing? Okay, it's fine? Okay. Whereas a notice was issued with a letter so-and-so to Unitech to show cause, to defend their case and to
So what is the
explain-
ground they have taken?
Yes, Lordship, the next paragraph, 1.1, 1.0. This is the ground. That it has been reported, alleged, please mark Your Lordship, reported and alleged, because my argument turns on this, about the commission of corruption by Messrs UDTL, that's us, including 2 officials of the company in collusion with an officer of oil while dealing, executing purchase, procurement orders of Oil India Limited. In this regard, oil has received a letter from CBI bearing reference number so-and-so dated 4/5/2025, along with a copy of the first information report stating that about the arrest of 1 officer from oil along with officials of the UDTL. The FIR pertains to alleged offense of corruption and bribery of public servant by private person and the commercial organization in criminal conspiracy. So filing of this FIR is the basis for the first, this is the basis. Second paragraph, Your Lordship. Just a few words I want to draw Your Lordship's attention. That the allegations set forth in paragraph, Lordship may mark prima facie. This is their own banning order. Prima facie indicates UDTL has violated 2.1.1 of the Integrity Pact. And Your Lordship, the Integrity Pact talk about no corruption. Thereafter, Your Lordship, they deal with the details of show cause notice reply. We came to court against show cause notice. In the meanwhile, banning order came, so we withdrew. And we asked for documents, we never got it. Even this particular FIR and the letter was given to us during course of hearing. We wanted a
filed an
personal.
appeal. You filed an appeal.
No, Your Lordship, we withdrew. We withdrew that writ petition.
No, you filed an appeal.
Before this, against, yes, Your Lordship, that appeal also was dismissed.
Because some writ petition was filed and I granted.
Yes, that is against a show cause notice. That is against a show cause notice, then it was withdrawn because the banning order came in. Page 241, Your Lordship.
Yes, now what is?
Lordship, page 241 is your Lordship's order.
An agency can be filed for debarment if it is determined that the bidder has breached code 70, so and so, so and so. Thus, the undersigned of the application and up to you on the entire matter of document. Now, what is the violation?
Yes, Your Lordship. Lordship, page 245.
Understood. Where is the value? The FIR has now been registered as miscase. so
Lordship,
and so.
I'm again drawing Your Lordship's attention. There are about 4 places where they say constitutes prima facie on the first bullet, page 245. Then, Your Lordship, the next paragraph, therefore, it is prima facie established. Therefore, 8 is prima facie established. And Lordship may finally then turn to page 246. After 4 times prima facie.
Understood. Let us omit the prima facie, but what is the,
No,
what
that
you
is-
have done? Madam, I understand what you are going to say. When it is prima facie, you cannot without a final year. But my question is, what is the transgression they have committed?
Except this FIR, nothing. Lordship,
That is what they have
nothing
committed.
else.
No,
Nothing
what
else.
is the finding? FIR lodged by CBI.
55, Your Lordship. That is
Accusing the officials of oil and so constitutes prima facie evidence of violation of so. The said FIR has now been registered as miscase in the court of so-and-so. An order has taken for cognizance of the offence under so-and-so. FIR empowers the procuring heir to appropriate measures under establishing heir. No, therefore my question is, wait, let us see 7. The procuring heir after giving revision
Yes.
or viewing heard come to the conclusion the bidder or the heir so-and-so has contravened the conduct of heir may take appropriate measures. So my question is, where is the violation?
Except for FIR, nothing else. That is,
And the cognizance.
that is my submission, your lordship. Our banning for 2 years is on the basis of an FIR being registered. Now, lordship,
No.
there is no other contract.
FIR and cognizance.
Yes, that's it. Yes, yes. And
Merely cognizance taken or an FIR filed can be a
Yes.
ground for banning.
lordship,
That is
lordship.
why I'm asking.
Yes, that is the long and short of the case. And lordship may kindly turn to the banning order, page 34.
Isn't 245 the one?
That is the banning order. This is, sorry, the banning policy. 234, page 34, the banning policy. On the base, they've quoted it, so I did not go through it because I'll take you through their banning policy. This is the Oil India banning policy. This is Ministry of Finance, guidelines for debarment of erring and defaulting bidders. This is what they rely on.
Okay, an agency can be considered for debarment if it is determined that the vendor.
Lordship, first is clause 4, or guideline 4, page 36. And Lordship has noticed they relied on this. Lordship 4.1, may I read? Lordship has 4.1 at page
Yes,
36.
No, I've read it.
No, Lordship, if it is determined that there's a breach of code of integrity, so there has to be a determination. And Lordship, what is the code of integrity? Rule 175. Lordship will find rule 175 at 51. Lordship may straight away go there. First is 175.1, which basically says you will not bribe. 175.2 is important. The next page, Your Lordship, 52. 175.2, the procuring entity, after being given a reasonable opportunity of being heard, comes to the conclusion that the
175.
175.2. 175.1 talks about not taking bribe. The other is 175.2. The procuring entity, after giving reasonable opportunity of being heard, comes to the conclusion that a bidder or prospective bidder, as the case may be, has contravened the code of integrity, may take appropriate measures.
But what do you say about 151?
Lordship, 151 is even better. It's a conviction.
Does it say that merely filing an
Lordship,
FIR or our cognizance being taken would amount to banning?
Lordship, one, a bidder shall be debarred if he has been convicted of an offense. It's better than 175.2. Clause 4 requires a determination of breach. 175 requires a conclusion. 151 requires a conviction. The only place where there is a prima facie is for suspension, and that can't be, that's 4.3 at page 38. You can...
So the major ground out here is nothing more than page 245, bullet point 1 and 2.
245? Yes, Your Lordship. Obliged.
That's it.
Yes, obliged. Yes, Your Lordship. And the finding, Lordship, at 4 pages, I had pointed out prima facie.
Let us not, but can these be the ground?
Or a prima facie determination, just mere filing of an FIR. Now,
By remand it back, they may say that, okay, remove the prime facie, again come back.
yes, Your Lordship. Yes, okay. I bow down to that. Yes, yes, yes.
Better to
Lordship, may I take you to the committee deliberation? There's a committee, because under these banning policy, there's like a whole procedure that has to be followed before banning. So there was a committee
Okay,
constituted.
but major question is these two.
Yes, yes. And Lordship, may I submit the final? There's a lot more point. We've got bail. Bailing order says bail orders recognize that there is no evidence against us. Therefore, they were, all three are granted bail. And if your lordship,
The bail is also the same,
yes, yes.
also in the same
Yes,
standing like the
yes,
FIR on.
absolutely. Only thing is the committee, again, the committee that advises banning also is on a prima facie. In fact, lordship if lordship has indulged me so much, you'll indulge me 5 more minutes.
Yeah,
Lordship, obliged.
you got
Lordship,
10 minutes.
committee is at,
But this matter I'm taking up at your own volition, huh? It should not be later on say that this court is sitting the 5:30.
lordship, that is an unfair thing on me. I will never complain about something that I've asked. I'm obliged deeply.
Now, my question is this too.
I have asked for urgency and your lordship has
these are the
obliged me.
two
I will
things
never
which
complain
are-
behind your back. Yeah.
Which are required.
Committee-
No,
Lordship,
only thing is
397.
unless the policy says, banning policy says that an FIR is filed or a cognizance is taken, there would be a violation of the Integrity Pact. There is no way out on this. It can be legally speaking. FIR and taking of cognizance cannot be a
Ground for banning. That is the short
Legally
and yeah, on the basis of this. That is, and lordship may kindly look at the committee, which bolsters my case more. Their committee, lordship, page 394. And lordship, there's one more point, which is really the nail in the coffin. Page 394. This is their finding. The committee which recommends 394, your lordship. These are all the deliberations. 398. 398 observations. 3.1, and lordship, I'll read quickly. 3.1, committee noted that in the order dated so-and-so, supply and commission of truck-mounted violence which was involved, both suspected oil name so-and-so, so-and-so. Now, however is important, your lordship. However, it is observed that the FIR does not mention any specific tender, purchase, order, or contract. In the absence of such particulars, it's not feasible to undertake any order, tender, specific examination to identify potential breach of integrity. That is their statement. Lordship, the next page, 3.3, the fifth paragraph. Lordship, 399 has, lordship has 399. 3.3, the fifth paragraph. The committee observed. Lordship, has the committee observed? Lordship has? The committee observed that based on available information, no conclusive evidence or conviction has been established to date. Oil's banning policy does not contain specific provisions for cases under investigation by government agencies or those that are sub judice. However, FIR lodged by the CBI accusing officials of oil and UTD Limited is not merely an allegation but formal investigative step, which constitutes strong prima facie evidence for violation of 2.1.1. So they said there is no evidence. And then they go on to say that the banning policy says not more than 2 years. And then they go on to say no. And the recommendation A, based on FIR, there's a prima facie case and therefore should be banned. And lordship, we are the only manufacturer in
They
India.
mentioned at 3.5.
Yes.
They don't want to carry on business. with
Yes. Now the nail in the coffin, your lordship. And I'm saying this on instructions, they will make it good. The public servant who's asked for the bribe, a functionary of Oil India, which has invited this FIR and a PC Act violation, has been reinstated by them. He's back to his job. So the main accused is back, decided by Oil as not guilty, and the alleged accomplice is banned for 2 years.
You understand? There are many judgments which says what a FIR to obviously there has nothing to do.
Yes,
but I'm
yes.
saying about the charge sheet. It's merely
Innocence
an
of guilt,
opinion.
presumption of innocence of guilt.
No, it's always an opinion
Yes, yes,
of the investigating
yes,
authority.
yes.
Only on the basis of opinion, there be a bar.
Lordship, there's a coordinate judge bench of this court which dealt with something similar and said FIR is the first step and it can't result in banning. Lordship,
No. And the next one is, I'm otherwise convinced with this aspect With
Lordship-
page 245 only I am convinced.
Yes.
I'm not
And
doing
I have a case law which says that,
unless it says,
yes,
because in the integrative pack, you enter into an integrative pack and there you find out that if there is a case pending against me in a criminal court, then I may be banned. Or do you, yes, they may cancel a contract. But banning is different.
Yes,
Taking
it's a-
into
it's a
account
civil
that
death.
the moment you are banned here, you are banned everywhere.
yes, that is what they say.
Oh, the
Yeah,
scope is
yes,
as
yes.
much here.
In
You
fact,
may
your
say
lordship,
that, okay, I don't
lordship-
want to enter into an agreement for some days. You are doing it only for yourself. For cancellation of a contract, that is a question of a breach.
And you claim
But
damages if
which
you're
one
right,
is
wrong.
For banning.
Yes,
There's
yes.
a-
It's a drastic
It's a
step.
drastic, yeah.
Lordship, Eurisham is a case, Lordship already knows it, so I will not place it. Eurisham is a case where there was a FERA violation on the basis which there was ban. And the court said, sorry, no. Of course, the show cause notice is not detailed, but there are observations there which says banning is what is falling from your lordship. It's a drastic, it's not pertaining to this tender, it expands
When
beyond.
your reply, when?
And lordship, they must on affidavit say whether they've reinstated the main accused or not.
That is on.
No, lordship, that is everything.
On the service jurisprudence, there may be different.
No, lordship, look, my
is
point,
commercial.
lordship, there is, lordship, may kindly, I can't believe I'm hearing this, but your lordship, there is an FIR. The person who demands the corruption.
Let us not go into that.
No,
aspect.
lordship,
You see, once I am not, let them come up
Okay,
with
Lordship.
something
Yes.
as 245 and these be the grounds for banning. And if they satisfy me, then I will go to the other point.
lordship, I
Let
will
us
not
now say, if the banning policy says that if an FIR is being filed, the banning policy says that if there is a cognizance taken, they would, because these are the only two points.
Yes, your lordship. So my submission is that's a jurisdictional fact. The banning requires determination, conclusion, or conviction. Short of that jurisdictional fact, you cannot invoke the power to ban. And lordship, for that, I rely on a Supreme Court judgment. Lordship, lordship wants to see it or?
Not, let him reply. I'm satisfied with you. In
Obliged.
fact, during the day,
I reserve my reply because my senior will be leading me in this matter, but just without lordship holding it against me, one aspect, what has been submitted probably is not supported by the record. We have proceeded based on our integrity pact. The integrity pact speaks of a different situation. It speaks of a situation where there is an incident of any corrupt activity been happening, of furnishing of money, or for that matter, any material or immaterial benefit. That is one aspect. Now, if there is a violation of that integrity pact, then there is a provision for banning under the integrity pact itself. Now, we have a banning policy also. The banning policy has not been placed to a lordship. Under the banning policy also, there is a particular clause which says any corrupt activities in the form of giving of money or undue influence.
But where is the finding
The finding,
that they have given the money?
it was a trap proceeding done by the
Understood.
CBI.
No,
where
all
persons were
understood.
arrested when
All,
submitting money
no,
and
Mr.
the admission is there.
Mr. Sharma, all understood. It's a trap procedure.
Lordship, that's a finding again.
Madam.
No, that's
Madam,
misleading the
please
court,
take
your
it.
lordship.
Madam, please take it.
It is there.
If there is a trap proceedings also, understood. But there are two aspects on a trap proceeding. One is a criminal proceedings, which has led to the FIR, which has led to the
Charge sheet and now
the
there's
charge sheet and
the
whatever.
trial
matter.
is pending against
Yeah, it's
the
a pen.
office. That is there.
But that is to be tested on beyond reasonable doubt.
That is a separate aspect. Yes.
But there is another aspect as regards the bribe having been given to an officer. That's
For
pre-
securing sensitive
there,
information of the
there is a
victim.
question of preponderance of probability qua a service jurisprudence. Qua service jurisprudence. Is there any finding to that effect that they have been involved to that effect? And if that be so, have you placed it to them about this thing that this is a finding? Because what is here is an allegation. What you are making the submission. It is mere allegation that yes, this person was caught red-handed. But for law, for the court is a different aspect. We can't look into it. We may say, yes, it is so, just outside, like madam's parent company, outside, not here. So therefore, here we need to come up, you have to categorically say out here that you have some materials and that if those materials are not mentioned in your banning order, can it survive?
I will take recourse to the recommendation of the committee. The committee is.
No.
Well,
The
if you
recommend,
satisfy
can
with
you
the
say the
findings.
recommend, can you say that the recommendation would substitute the reasons required in the order? No, the order has to speak for itself. So therefore, your reasons has to be there in the order. Now, after this order, your basic reason is twofold, which is that 245, FIR and a cognizance. Now, if you see at the recommendations that more particularly at 3.5, your basis is, look here, this person, some FIR is being filed, somebody has done, or here a case is there, we should not have any business. That's paragraph 3.5. Can that be the
That is our
ground?
integrity pact. That is our integrity pact.
Understood. But your integrity pact says conviction.
No, it doesn't say so. Lordship, what has been read is the
Integrity
CFR
pact says that there is a case of corruption. But where is the
151.
finding?
What was read was 151.1. Lordship will read 151 Roman 3. It speaks about violation of integrity pact. If the violation of integrity pact also.
No, does the,
proceed for
okay,
banning.
very well. Let us understand that if there is a violation of the integrity pact, does it say
Lordship will
in
read
the
2.1.1.
integrity pact, in the integrity pact, does it say, isn't there a requirement of a finding prior to that? My question is this, whether there is a requirement of a finding, concrete finding, to the effect that yes,
Extent of any.
not to aspect of criminal charges. No, I'm not saying on that.
Not to the extent.
But there has to be some inquiry made by you to the effect, yes, this has happened.
A determination.
And on the basis thereof, you take.
The FIR, the cognizance report, where a judicial court has taken cognizance based on a charge sheet been submitted before.
That is a different. Cognizance
those
taken,
mentioned before
if a
us.
cognizance taken is tomorrow taken, it will have far-reaching consequences. Merely on the basis of cognizance, you cannot. Yes, in TV it may be, but not here. So therefore, we are to hear from you on the next date or from your senior, whoever it is, as to whether merely on the basis of page 245, the reasons, can you go so? If there is other materials where which it is seen that look here, we have investigated, internal investigation, we found out that this has happened, he was involved, and on the basis of that we have done. If there is a mention in the banning order, yes, he has done so. For the purpose of our inquiry, it is there. Maybe for criminal proceeding is a different thing. But for our inquiry is there. If that is there, very well you can. But that if that is not there, this court have no other way. Chalo, hearing part when
Lordship,
somebody's life and death is in question.
yes, Your Lordship, we've missed a lot of, and I think they're imminent in September. And Lordship, we have 32 patents. We're the only one, it's actually not in their interest either to ban us. I don't know why they have. We are the only manufacturer and supplier of those winches of that specification in India.
Then how could they miss out in a contract in Oil India Limited?
Because the
We are
depth,
relying on them only for that winches.
no, because the specification has been changed. It depends on the depth of the well.
Whatever. Maybe day after.
I have limited the matter into small
Yes,
things.
I'm obliged. That is the long and the short of the case, Your Lordship.
Day after tomorrow.
It's inconclusive. Establish this matter on. কিমান দিয়া আছে 18 তাৰিখে কিমানটা আছে
My instruction.
18 20 তাৰিখে 20টা 28 আৰু 2টা বজাত Twenty-fifth.
Obliged, Your
25th.
Lordship.
20
And obliged for a after court hearing, Your Lordship.
Yeah.
Much obliged.